All mics are hot.
Just know you'll be recorded. There you go.
It's up to you. You're chairman. I need you to be able to kick me under the table. All right, there we go. Do you need a script? No, yeah. And your script doesn't quite follow the bylaws, but we can talk about that later date. So I kind of did my own track. Let's see how it goes. All right, I should spread out. I've got straight up 5. Well, we got 4 out of 5, so I'm ready to roll. Anybody object? I mean, okay, let's call this meeting to order and Secretary call a roll. Is that Joe or David? Yeah.
Either way,
Go ahead, David.
sure.
Right.
Mr. Kennedy. Here. Mr. Thine.
Unless he's that missing number. Jeff, if you're there, let us know. Okay, let's call him absent for the moment.
Okay. Ms. Hanning.
Here.
Mr. Platt.
Here.
And Mr. Hinckley.
Here. Okay, thank you all for coming sort of out on a cold winter night as it suited you. Since this is my first session as chair, let me start with a few plenary remarks. My job is to run an orderly meeting. We will proceed as per Robert's rules of order and our bylaws for the most part. But for those of you who are Robert's rules students, you would note that there are some more relaxed standards for small assemblies, and I think that's appropriate. We aren't 500. We don't need to do this like we were the U.S. Congress, so we can proceed somewhat informally. But certainly, if anything seems to be straying, nobody should feel shy at all about reminding us and me of that. And any decision of the chair in terms of recognizing folks or motions is appealable to the body. So again, I'm not the boss. I'm got the dubious assignment of trying to herd things forward in a halfway coherent way. So anything, if there's anything you don't like the way it's going, certainly holler or get a hold of me afterwards. We can change it for the order of events if you don't feel like you've had a chance to be heard adequately. Again, nobody should be the least bit shy. We're just the 5 of us, and we're trying to do the county's business as best we can. Okay, first item on the agenda is the agenda. Again, just to remind ourselves, the agenda is drafted by staff initially, and then it's coordinated with the chair. That's a standard chairly duty is to put things on or off the agenda. Any of the members of the commission that want to put anything on the agenda, again, don't be shy. Tell David or myself that you'd like an opportunity to address a certain topic, and then we can decide how to proceed. I don't know what that even means, so that's on my list to discuss later on. We need to excuse. I mean, I don't know what.
That's what we've always done by the script, but I don't know if it's necessary or not. I mean, I think the only thing it would be is if there's unexcused, if they're not excused, then that's, if they miss so many meetings, that's termed for dismissal or something.
I believe it's 3.
But yeah, so that would be the only, if you want to excuse them, then that doesn't.
I'm happy to let it go. We don't know what Mr. Dine's situation is.
Sure.
So again, it's a good question, Joe, and thank you for bringing that up. I had thought about that. Felt like we would excuse people if we were aware of an excuse, just to make sense of the concept. Okay, on the agenda, something I've added to the standard agenda down there towards the bottom was commissioner comments, And what my intention there was that sometimes and I'm probably the most guilty over the last year of using a specific application that's in front of us to explore wider topics. And to some extent, that really wasn't fair to the applicants. And I had a conversation with Ms. Powell after one of those meetings. I said, I'm sorry, we kind of sucked you into this bigger discussion. So my intention there is we're going to learn as we go along, and certainly, particularly the new members, don't be shy about asking questions of staff. What is a conditional use? What are the situations? Because we'll learn best with the specific application in front of us. But I deliberately put that commission comments piece on our agenda for, well, actually kind of an extended version of that training session that staff put on for us. So there will be a place for us to discuss more general questions about what we're doing, how we're doing it. That's what that's for. We can use it or not as seems appropriate. Okay, so you have agenda in front of you. Are there thoughts, comments, requests to modify that agenda?
Order, Mr. Chairman, I would move to excuse Mr. Tyne.
There's been a motion to excuse Mr. Thine. It's been seconded. Is there any discussion of that? Hearing none, let's just go with all in favor, say aye. Raise your hand, you guys on the screen. We'll call it an aye.
Aye.
Okay, done. Mr. Thine is formally excused. Okay, does that adequately address your point of order, Mr. Kennedy?
Yes, it does.
Okay, thank you. We're back
And
on the agenda.
I would move to approve the agenda with the addition, I had mentioned to David that we ought to discuss rules and procedure and maybe what he's found on research.
Okay, does that sound like my commissioner comments, or is that?
Close, yeah. We can work it in there. We can work it in there.
Okay. That sounds like the kind of thing I had in mind. Okay, are there others? There's a motion on the floor, and was there a second to that? To approve the agenda?
I'll second that.
It's been seconded. David, you got a comment?
So I don't know if you would want to put this on here or want to do it at another meeting, but Matt has been working on some revisions to this subdivision regulations, and we kind of have a big question that we want to bring to you guys before we can kind of move forward with that. And so we were wondering if we could have a brief discussion on the subdivision updates that we're working on.
Okay.
That could be under cover planning somewhere.
Yeah, it sounds like it's of a piece with our zoning regulation review. Yeah. It would be subdivision regulation review.
Yeah, it's a separate resolution, but yeah.
Right. Okay. I'm not averse to calling it a 3A or 3B.
Okay.
If that's acceptable, I guess David can't make motions to amend. Anybody want to? Right.
I move to so amend.
Thank you. Is there a second? Well, is that acceptable to the mover? I guess I could call it friendly amendment. You okay with that?
Yeah. Yeah. We're good.
All right. Everybody
Andy
happy?
will second.
Okay. So are there further amendments to the agenda? Hearing none, let's bring the motion to a vote. All in favor of approving the agenda as amended, say aye or raise your hand. Aye.
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 Unanimous. Thank you. Okay, minutes is the next thing up. Again, just a brief plenary statement. If there's something more that you'd like to see in the minutes or less, Joe has been the main author of those. He's been very amenable to comments. So the point of the minutes, one is they've become a kind of a table of contents for the video, because that's the real record. But if there's something more you would like that's within reason for the limited staff time available to us, the minutes are for our benefit. So feel free to offer your thoughts on the nature, structure, content of the minutes. So given that we have minutes in front of us for the February meeting, do we have let's start with the motion. A motion to approve those, we can amend it as necessary.
I move to approve minutes.
We have a motion to approve, second. Okay, open to discussion. Anybody want to comment on the minutes?
I'd call a question.
Any comments? Michael, Mara? Okay, hearing none. Those in favor of approving the minutes as distributed, say aye, raise your hand. Aye.
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 That's unanimous. Thank you. Disclosures, Mr. Kennedy.
None?
Ms. Hanning?
Nothing here.
Mr. Platt?
None.
And none from me. Thank you. Public applications. Now, I'm told by Mr. Gertz that these are officially public hearings. We often don't call them that, but am I understanding that correctly?
According to the bylaws, it seems that that's what they should be called, as public hearings.
Okay, so we're opening a public hearing. And the order of these public applications, it is consistent with bylaws, is that we will have a staff report. We'll have an opportunity for commissioners to question staff. And by staff, I'm including both our legal personnel from the county attorney's office, as well as the planning office staff that are here with us today. We'll follow that with comments from the applicant, if there are any, and an opportunity for commissioners to question the applicant. Then we'll open it to public comments. And quoting from the bylaws, Albany County encourages public participation in the planning process. The intent of the above rules is to allow maximum public participation while providing an equal and timely schedule for consideration of agenda items. So we will proceed with public comments in that spirit. Public or will require you to give us your name if you're going to speak. It would be helpful if you let us know whether you were speaking for or against the approval of the application before us. And our bylaws suggest a 5-minute max. So we'll see how that goes. Most comments can be dispatched in that amount of time, but do be respectful of your fellow commenters. At that point, we'll close the public hearing. We have a discussion by the commission, which will result in a motion of some point, which will then be debated and brought to a vote to make a final decision. All those decisions are made by a majority vote of the commissioners. Given that there are only 4 of us, I would remind us that a tie vote is a loss. Okay, any questions on procedure? Mr. Platt, does that satisfy your?
That's fine.
Your questions? Okay. First up is the Carbon Black Power Conditional Use Application CU0222. Mr. Gertz.
Yeah, Mr. Chairman, this is a request from Carbon Power and Light for a conditional use permit for an electrical substation. The substation will be located north of the intersection of Herrick Lane, Dutton Creek Road, and Mandel Lane. This portion that we're looking at here is zoned agricultural. They had a piece of property that they already had a substation on, and they have included some more property into that. And so it's basically this additional property that we're looking at where they're going to be putting this substation. At least the majority of that, the construction will be in that property. So this application was provided to other agencies and organizations to provide any reviews or comments that they may have. Wyoming Department of Transportation was the only one that commented on this project. They just noted that if there's any drainage that's going to be coming off of this property that is above historic rates, they'll need to do a study to determine basically a runoff study, a drainage study, and look at that. Or if there's any changes to their access to the property off of their right of way, they'll have to get permitting through that. And I think this is kind of a standard comment from them. So I know that they'll be working with White, at least on the other project, to upgrade and access, but this access is going to be from the same spot. There shouldn't be any additions or changes to the current access that we'll be using, from my understanding of what we have here. So the applicant provided a complete application. They addressed the impacts to the project, or the project may affect, and then basically my analysis of the project is that notice was required as provided. The applicant has provided a complete application, has addressed the potential impacts this use may cause. The original property owned by Carbon Power Lights is currently being used for an electrical substation. Rebuilding of the substation on the property recently acquired by Carbon Power and Light should have minimal negative impacts on the surrounding area, and the reconstruction of the substation will provide additional electrical capacity in the area to in support of the current and future land uses in the area. Findings of fact, findings necessary for approval, applicant responses, and staff analysis referenced in this report are adopted as findings of fact, reflecting the applicant that the applicant has adequately addressed the specific impacts, and the same are incorporated herein. Conclusions of law, the applicant is proceeding in accordance with and in compliance with the requirements of the Albany County zoning resolution. Staff is recommending approval of this application, adopting and incorporating the findings of fact, or the staff analysis findings of fact and conclusions of law, as each are stated in the staff report. And so if you have any questions for me, I'd be happy to answer those. And we also have Jim Beckman from Carbon Power and Light. He's with us via Zoom. And so if you have any questions for the applicant, he'll also be online to answer those. But at this point, if you have any questions for me, I'd be happy to try to answer those or defer those to the applicants.
Okay, thank you. Let's just go around Robin here. Mr. Kennedy, if you've got any comments, questions on this with respect to the staff report.
I don't have any questions on the staff report.
Ms. Hanning?
Thank you, Mr. Chair. I just have a quick question, and it may be best addressed to the applicant. You'll have to let me know, David. How is the wrecking out of the old substation overseen? Is that something that is handled under the previous conditional use permit for the substation? And do you know what, is that a pretty immediate decommissioning, disassembling, or might it sit there for a long time before that is undertaken?
I think the decommissioning of the substation that they're removing, that's probably a good question for Mr. Beckman. I would just make a guess. I don't know all the whole history of this property, but I don't believe that there was probably a conditional use permit required at the time that the existing substation went in. I think it's probably been there for many years, maybe even prior to zoning in the county. So, but Mr. Beckman can answer the other questions.
All right, we'll come to you, Mr. Beckman. You can hold that thought, and you too, Ms. Hanning. Other comments, questions, Ms. Hanning?
No, thanks. I'll wait to hear from the applicant.
I have several questions. One question for you, Mr. George, is when an application comes in, do you generally conduct an application or a pre-application conference with the applicant to talk about various aspects of it? Or how's that handled?
Yeah, so Mr. Chair, typically, yeah, we will discuss projects. Depending on the project, I mean, a lot of our pre-application meetings may just be over the phone. We discuss what's needed, what we're looking for, just the application procedure. We will do that, especially when like a conditional use or even a zoning change. They're pretty informal. With a subdivision application, it's a little bit different, which this isn't a subdivision. They do come in, they bring us a plat and show us what they're doing. But yeah, we do it informally. There are some folks that do come into the office, but there's a lot of times we can just look at a map over the phone and, look on my computer screen and discuss those and just go through the process. So typically we don't just receive an application out of the blue. Mr. Beckman has contacted our office and we've been working with him for quite a while before he turned in the applications for these conditional uses. So.
And does a comprehensive plan ever come to use during that part of an application? Does it ever come up?
The conditional use, I actually glanced at the conditional use on this project, and with conditional uses, there's not a whole lot of guidance when it comes to what they're doing. The only guidance you would find on this project is basically referring to regional planning on the issue of utilities, which really doesn't, affect this project at all. But yeah, I mean, we do look at that. If it was a different project, maybe we would look a little bit more and just let folks know what it says in there. But the comp plan does get looked at least, and information's passed on.
Okay, and then my final question, it's actually not pertinent to this particular application, but it appears here. Under findings necessary for approval, paragraph D1 or subparagraph D1, how you call it, where it says comprehensive plan. Underneath that, it says above provision, found in chapter 5. I'm not going to read the whole thing.
Right.
That was stricken.
I've got it here. Do you want me to quote from the staff report?
Oh, that's what I'm looking at right now. Oh, excuse me. Yeah, that's there. It reads, this above provision cannot be required due to the state statute. I'm going to read that, 201A. Where did that text come from?
Which text?
The text that I was just referred to. The text has been inserted. It's not part of the zoning resolution. The above provision, etc. Where did that block?
Well, I actually added that to this.
Okay. And that was your decision. That was anyone's direction.
No, actually, that was my decision.
Okay, but that's all I want to ask about. But I want to come back to this and our agenda items down at Commissioner's comments.
Yeah, and it's actually to some extent on the agenda under zoning resolution review.
Okay, great. Thank you, Mr. Griffin.
Can I just, so it wasn't I wrote this or whatever, but we did receive guidance from the county attorney's office that we should not use the comprehensive plan in such decisions. So I just put it in my own.
Yes, no, I'm just,
that makes sense.
Yeah, Don, I'm going to come back to it. I just want to raise it now that my question also applies to the next application also sits up here.
Sure.
There again. I'm not going to raise it again. I'm going to double it.
Further questions on this application?
Yeah.
Thank you. Okay, I've got a few. The first one I'd pick right up on what Platt said. I think that the statement is a big improvement over previous staff reports, which have just said that thing's gone. But I think a better reading of the perhaps somewhat obscure change in state statute would be that we cannot base our decision on that. And I'm looking up the side of my eyes at Mr. Ayers. So it seems to me that perhaps something of a compromise position at this point would be that we cannot base a decision on the comp plan. But I think that is still relevant background. So speaking for myself, I think it would still be appropriate for staff to enlighten us on how all these applications fit in to the comp plan, with the understanding that when we come to a decision point, we cannot rely on that. Is that fair, Mr. Ayers?
Yes.
Thank you. So tell us about what does the comp plan say, anything that would bear on this particular application?
No, and there's only one section that it talks about it. I think it's like chapter 10 or 12 or something like that, but it just mentions coordinating and creating some kind of a regional plan to make sure that areas in the rural areas have access to electricity, basically. So, I mean, I guess in the broad sense, this is furthering that because there's going to be greater capacity at the substation, or the substation will have greater capacity, be able to serve more area and more uses. So in a way that I guess it's following what it's suggesting in there in a roundabout way. So
that sounds completely appropriate to me, and the kind of thing that we'd like to know, that we weren't making a decision that was perhaps contrary to the comp plan. Sure. Then we could argue about, well, the reasons you're doing that. Now, just again, this is our first one, so appreciate your indulgence, Mr. Beckman, but and the staff reports are evolving. So I'd like to just dwell on the findings of fact for a minute, and those statements in our staff reports have evolved usefully over the last year and addressed some of my concerns that we meet our obligation to affirmatively find certain things. So condensing the sentence in staff recommendation, for example, it would read, the applicant responses are adopted as findings that the applicant has adequately addressed specified impacts. The key word there is adequately. I just want to emphasize to my comrades and myself that if the county approves this application as presented in the staff report, adopting findings of fact and so forth, we are saying that we, P&Z, have considered the impacts and affirmatively found them to be acceptable. Again, is that fair, Mr. Ayers? That we have to make a finding to approve of application of certain things. And in many cases, we simply say, here's what the applicant said, and that's okay with us. Okay, Mr. Ayers is going to address my concern.
Oh,
Please.
yeah, Mr. Chair, for public hearings specifically, the findings of fact and conclusions of law are not required to the same extent as a contested case hearing would be. It doesn't need to be a written, something akin to a court order, essentially, that you would find out of, say, the County Board of Equalization. So what needs to be found is what are the findings required within the subdivision resolution or the subdivision resolution. And these, yeah, the findings required for approval are those findings. So however it needs to say, or however it can be said that those findings necessary for approval, I suppose, have been adequately or have been positively found. But is that?
Yeah, no, that sounds
answer?
to me like we're saying the same thing. But
Okay.
For example, just picking one at random, we have to find air quality, that the applicant has adequately addressed mitigation of air quality impact at or beyond the property line. Our staff report simply quotes from the applicant response. So that in itself is not a finding of fact. That's simply a recitation of what the applicant said. But when we come down to the bottom, where we say we are embracing the applicant responses as our findings,
Well,
that's the point that I'm.
it also has to be read in conjunction with, I suppose, subparagraph D, under which all of these impacts are listed, that the applicant has adequately addressed the following impacts.
Right.
And that's the regulatory language. So it's not necessarily just a finding on your behalf that you don't think there will be air quality impacts or water, but that the applicant has adequately addressed the following impacts. And that's just from the regulatory language.
We, the county, are saying
That this is
that this
adequate.
has been, is that.
Sure.
Right. Yeah. It's just that the way these are worded sometimes, I don't think there will be any impacts language is quoted from the applicant. And we are saying, and we agree with the applicant.
Or that we have found that they have adequately addressed.
Yes. Okay. I think we're on the same page.
Okay.
My point is that we are the ones making the findings.
Correct.
Yes. Okay. Thank you. And that is reflected at the end of the staff recommendation, and it's the guts of the script that Joe has sent around. That's the point at which we have adopted those findings as our own. And as he's offered to us in the possible, the planning and zoning, three possibilities: approve, approve with conditions, and deny. I think that's important to then point out. This is something that's done a better job over the last year, that if we were to move to approve, then we have the findings of fact that staff has prepared for us. If we, in contrast, did not want to approve the condition and the recommendation of staff, we would need to flesh out our motion, as is indicated here in the staff report, with findings of fact. Now, that requires us to kind of jump in and do some drafting on the spot. I assume that the courts would cut us a little slack on there, but the point of this is that we need to articulate reasons for approval or denial. And that's just an important thing that I think sometimes gets lost in the less formal proceedings. So, Mr. Gertsch, would you comment on that, or shall I proceed?
Yeah, I'd just say that, yeah, if we're looking at it and there's just things we want to amend in the staff report, we can amend the staff report, amend the findings that are already there if that's what it takes. If it's totally different, then yeah, we'll have to do some drafting, I guess.
Or we can add conditions.
Sure,
But
absolutely.
just advice to my colleagues, we don't have to. Our staff typically does a very nice job. The fact that we very, very rarely do other than the staff recommendation doesn't mean that we're just rubber stamping. It means that the staff's done a good job in working with the applicant to bring us a well-articulated complete application. All right, moving on from that point, just a little feedback on staff reports. A little wider area map would be helpful to me. Okay. For those of us who don't know the whole thing, it would add one page to these, but I find myself bringing up Google Earth and trying to figure out where is southwest quarter of section such and such and such and such.
Okay.
Just a very small bit of feedback for better orientation for us. To the substance of the application, finally, Mr. Beckman, if I understood your comments earlier, Mr. Gertsch, the YDOT, that's nothing we need to think of as conditions. They will have to deal with YDOT, and it's clear that they will just take care of this. Okay, thank you. That's all I have. Mr. Beckman, you're up. If you can remember Mara's question, or you want her to repeat it?
No, I believe she inquired about the decommissioning of the existing substation. The way it'll work is once the new, can everyone hear me all right?
Yes, thank you.
Okay. Once the new substation has been built, we will have to energize it. Once it's energized, then we go through a testing process to make sure that all the protection mechanisms within the substation are working properly, that there aren't any issues with the power transformer, and to just make sure that it's gone as designed. Once the new substation has passed all the necessary testing requirements, then we will start cutting over the load from the existing lines to the new substation. Once the existing lines have been put on the new substation and there are no issues with all the new interconnections, which obviously we don't expect any, at that point, then we can de-energize the existing substation and we will then wreck it out. So we'll start removing the bigger equipment, hauling it off, and then basically once everything's removed from the site, we can then take the topsoil that remains from the site that's been cleared for the new substation and spread that topsoil on the old site and seed it at that time.
Thank you. Are there other questions for the applicant? And thank you, Mr. Beckman. Was that okay?
Thank you, Mr. Chair, and thank you, Mr. Beckman, for answering the questions about how you do that. In general, if everything goes more or less to plan with testing the new substation and bringing it online, how long would you say it would take to fully dismantle the decommissioned one and return it to pasture land?
My preference would be to have that done by fall, definitely before winter. A lot of it, as long as there aren't any hitches along the way, we should be able to do that. You know, should workload get bad or anything, then it would have to be the following spring, but certainly no more than that.
Great. Thanks so much for answering my questions. Thank you.
You're welcome. Thank you.
Other questions? Hearing none, let's open this for public comment.
Mr. Chairman, before you move on to public comment,
Yes, sir.
Mr. Beckman may have experienced the same thing I did, and there's some sort of feedback on your end from the commissioner room when we speak.
Okay, what do you think, Mr. Gertz? Should I try a different station, or
Is it just when,
is it just me? Is it
No,
all
it's
of us?
just when we speak, it's just when we speak that we get some feedback
Should we mute
from you
while they
guys.
speak? You sound good from here, but I bet that's it, is we're getting them back to our mics. So mute while they speak.
I turned down the volume, does this help any?
Well, testing 1, 2, 3. I still get a little bit of it, but I can live with it. I just didn't want you guys to think that that's what it was sounding like.
I just gotta remember to turn this back.
The Zoom
You
screen
can mute all
shows the commissioners and commissioner one. Oh yeah, maybe
They're-
muting one of the two would take care of the
Yeah,
problem.
yeah. I think it did. That did help it, Mara. Thanks. That's
Keep the
all.
feedback coming, because we don't hear your feedback. Okay, we're moving on to public comment on the substation application. I don't see a lot of folks on the screen. Could whoever is 970-411-1238, I guess you don't have to identify yourself, but I believe that's Susan Faraday. Would you like to? I guess, okay, no, not responding to that. Oh,
Hello, this is Connor Nicholas. I'm the 970 number. I'm just present for the Natural Resource Management Plan.
okay. So we're aware that that's what that mystery number is. Public comment going once, going twice. Hearing none, we will close the public hearing if there are no objections from the commissioners. Commissioners, what's your pleasure?
Mr. Chairman, I move to recommend approval of the Mecca conditional use application CU-01-22 to the Board of County Commissioners, incorporating the findings of fact and conclusions of law as listed in the staff report.
Second motion.
Okay, moved and seconded that we approve a well-crafted motion, thanks to our great staff reports.
Actually, it was, I think that was the old script. It should be the carbon power and light, conditional use.
Are
Okay,
you-
sorry.
I sent you the wrong
Sorry.
one.
I don't think I printed the last one. My bad.
Good job there. It's actually listed in the staff report correctly, I believe.
Yeah, it's right in the
Forget this, forget the script. Let's just go with the staff report.
Okay.
All right, you want to give that another try just for the record? I can read it.
Mr. Chairman, I recommend the Board of County Commissioners approve the Carbon Power and Light Incorporated Herrick Lane conditional use application CU-02-22, adopting and incorporating the staff analysis findings of fact and conclusions of laws as each are stated in the staff report.
Thank you. Is there a second?
A second.
Mr. Platt seconds. Discussion? Mr. Kennedy?
Question, aye.
Right, let's make sure we got no further discussion. Ms. Hanning, Mr. Platt? Okay, then we'll call for a vote. All in favor, say aye.
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 Do we need that a roll call, or we?
Mr. Chairman, I think a roll call is appropriate.
Let's do that. Mr. Kennedy?
Aye.
Ms. Hanning?
Aye.
Mr. Platt?
Aye.
And Mr. Hinckley? Aye. Thank you for that, that coaching, Mr. Kennedy. Moving on to Carbon Light Power Conditional Use Application CU-0302. Ms. Birch.
Mr. Chairman, Commissioners, this is a similar ask for carbon power and light, just a different area. It's adjacent to Highway or 296 Highway 11. It's approximately a third mile northeast of the intersection of State Highway 11 and Dinwiddie Road, if you know where that's at. Kind of in the Centennial Valley in between Centennial and Albany. So see, this property is zoned agricultural. Everything around it's pretty much agricultural. This is also on a site. The actual property was purchased by Carbon Power and Light that this will be on. Right next, kind of next door, they have their other substation that I believe they'll be replacing as well. This is a new property, but we've got pretty much the same response from Wyoming Department of Transportation about drainage and so they're right away. They actually have, as part of this application, I believe there's the approval of their access permit from YDOT. And so they went through that process and are already working with YDOT. So I just wanted to point that out. The Conservation District hadn't have any comments. Game and Fish had quite a few comments. They have had comments about this is crucial winter range, or I believe elk, deer, and pronghorn. So they have some recommendations for that. Basically, just don't disturb the area between November 15th and April 30th. So any construction should take place outside of that. They also commented on noxious weeds and invasive plants. Army Corps of Engineers, they brought up, there is a wetland that is right next to this property, maybe part of this property. I'm not quite sure exactly. I mean, I've got my mapping. I will note that the maps that I provided are made with the best data that we have, but they're by no way survey maps and may not be exactly accurate. So my placement of the box on the map may not be exactly where it would be on the property, if that makes sense. So it's just to give you an idea, but there is a wetland that's associated with that. I think I provided a map that shows that wetland. So anytime you're dealing with wetlands, the U.S. Army Corps of Engineers gets involved, and they would need to consult them and make sure that they're complying with any of their policies and regulations, and they possibly get a permit for them. And that's what Game and Fish had brought up. They're also just asking for best management practices to control erosion and prevent sediment from entering the waters there. Make sure that they don't bring any zebra mussels into the area and all that stuff. So, anyways, they've got their whole section. I included their letter in the back, but this is basically all the recommendations that I've put in the staff report. So findings necessary for approval, they have to provide a proper notice, address the findings that are required, including the site plan, addressing that, they address the impacts, showing that there's not going to be any harm to public health and safety and welfare. So their application provided information on all of these areas. So with that, the applicant has provided a complete application, address the potential impacts this use may cause. Rebuilding a substation should have minimal negative impacts on the surrounding areas. Proper care is taken to follow the recommendations in this report. The reconstruction of this substation will provide additional electrical capacity in the area. The applicant has received a permit from YDOT for access to the site from Highway 11, so they will not be using the current access that they were using for the other substation. So, and then Game and Fish provided a number of comments, and it's recommended that they follow those recommendations to avoid any impacts on the surrounding area, the waterways, the animals in the area, wildlife, and such. So findings of fact, findings necessary for approval, applicant responses to staff analysis referenced in this report are adopted as findings reflecting that the applicant has radically addressed the specific impacts and are the same are incorporated herein. Sorry, this is new language, so I'm used to here. The applicant is proceeding in accordance with and in compliance with the requirements of the Albany County zoning resolution. Staff recommends approval of the Carbon Power and Light Inc. Conditional use application, adopting and incorporating the staff analysis, findings of fact, conclusions of law, as each are stated in the staff report, along with the following conditions, just adherence to the recommendations of the Wyoming Game and Fish Department. And I guess that recommendation you guys can discuss that. That's recommended in my staff report. So whether we need to add that as a condition or not, I guess it's up to you if we're already referencing what needs to be done. I just thought it would be good to call that out just to make sure that that's a specific thing that they focus on and make sure that they're working with Game and Fish when they do this. So with that, I would take any questions. And again, Mr. Beckman's on the line to take any questions about their application.
Thank you. Mr. Kennedy.
I don't have any questions for staff. I will for Mr. Beckman a little later.
Thank you. Ms. Hamming.
Thank you, Mr. Chair. I think my questions are probably best addressed to Mr. Beckman also. Thank you.
Now, are you guys getting that feedback? Are we okay there? Mr. Kennedy, okay, so. All right, anything we can do to improve that, Mr. Platt?
I will also have questions for Mr. Beckman.
Okay. I just had one with respect to the Game and Fish and the Corps of Engineers wetlands. Was your feeling that the wetland concerns of the Corps were captured by the Game and Fish recommendations? Is that what I heard you to say, or is that a separate thing?
Yeah. I mean, they've captured that. Their recommendation is just to determine if there are wetlands on that property or where they're going to do their project. And so if they do that, then they would know if they needed any permitting or anything from them at that time. So, and maybe Mr. Beckman can answer that too. Maybe they've already done an analysis of that property to know whether there are wetlands on that property for sure.
Okay, we'll ask him, and my question then goes to the form of the motion. Mr. Ayers, can we adopt those conditions by reference, or do those need to be explicitly repeated in our motion if we were to approve this?
Mr. Chair, I believe that it would be better practice to explicitly incorporate those into the motion.
Okay, thank you. Further comments, questions for staff on this application? Seeing none, Mr. Beckman, you stand for questioning. If you'd like to make some comments to introduce the project, that would be fine.
Yes, for sure. As Mr. Gertz pointed out, we have worked with YDOT to obtain a permit and it's not going to be a new access. We're actually widening the existing access so we can get the trucks in and out of there. And then as far as the timing, I have notified the individual from Laramie that will be building the pad for us that no work can be performed on site until May 2nd. The 1st is on a Sunday. So on Monday, May 2nd would be when dirt work would begin. And then I'm currently working to make sure that we are out of a wetland with the Corps of Engineers. The surface itself is all sagebrush, which indicates to me that it's not wetland. As far as my knowledge goes, water tends to kill sagebrush, but I'm definitely working to get that clearance as well.
Questions for Mr. Beckman? Mr. Kennedy?
He just answered my question, but I would add I'm more than a little uncomfortable adding that condition because Game and Fish is out of their wheelhouse recommending Corps of Engineers on wetland because that isn't their jurisdiction. That's Wyoming DEQ and kind of the operator's burden is there. That's very far out of their wheelhouse to make any recommendations about consulting Corps of Engineers. The only other question that I'd have on their letter, and I'm sure that Carbon Power and Light is doing this, is the proper folks to consult with on revegetation probably isn't Weed and Pest, it's probably Laramie Rivers Conservation District and NRCS. So, and that's the only real comments. And Mr. Beckman, thank you for answering that question.
You're welcome. Thank you.
Well, we got any thoughts from staff on the Corps of Engineers jurisdictional question? I guess Mr. Beckman, I guess I'm just looking for, are you subject to Corps of Engineers permitting regardless of what we do, or is there any reason that we would want to make that a condition? Again, I'm opening that to our various advisors.
It's, you know, I've had to touch base with them a couple of times over the years. Of course, I want to make sure that we meet their requirements. I've never actually had a project where I needed to obtain a permit from them, but I always want to make sure we have that clearance before we proceed with anything. Obviously, we have to work with a lot of agencies, both at the state and federal level. So I think it's worth trying to meet everyone's expectations to foster those working relationships.
And Mr. Chairman, I'll make a comment. There was an abbreviation in there that some of you might not have understood, and that's Rural Utility Service, which is kind of almost one of Mr. Beckman's bosses as well, because they do a lot of the financing on these projects through USDA.
If I may add to that, yes, we are an RUS borrower. This project is funded by RUS funds. In order to obtain those funds, we not only implement a 20-year long-range plan, but a 4-year construction work plan. The funds for this project are from our current 4-year work plan, and as part of that, all agencies do have an opportunity to comment at that time as well. And so at that time, we contact the Corps as well as BLM and SHPO, about every agency you can think of.
Thank you. Mr. Kennedy?
No further questions. Thank you, Mr. Chairman.
Danny? You guys move around on the screen. We have to kind of catch you as you get up in a different corner. Do you have any questions or comments for the applicant, Ms. Hanning?
Oh, yes. Thank you, Mr. Chair. Mr. Beckman, how far away is the current energy substation that you're going to be decommissioning? Is it miles?
No, it is about 200 feet. The problem with the existing site that we have is currently, if we were to build to the boundary of that site, it would greatly obstruct the existing driveway to the residents that they have on the ranch there. So in seeking the new site, honestly, I tried to move the new site out to Highway 130, so it would have been miles away with better access for our linemen and inclement weather. Anyhow, I spoke to pretty much every landowner from Jack's Place to the current site, and the Ed Hall Ranch was the only one that was really willing to work with us, since we were able to do something with our current site. As part of obtaining the site, they requested that we go further off the driveway so it would be less visible from their homes down on the Little Laramie River off of Dinwiddie Road. So that's why we moved as far off the driveway as we did. It would have been my preference to be right there by the driveway where we had less work to do, essentially, and better access, because my biggest concern is snow drifting and obstructing access that way.
Yeah, I'm sorry to hear that the I mean, I can understand why the homeowner doesn't want to look at the substation, but I'm sorry to hear that it forced you to move further into the critical winter range for big game. Because while you're going to be minimizing construction during that period, the substation will be fenced off and it will remove a portion of that grazing area from the game. I mean, you have to fence your substation, I imagine, for safety.
Yes, the site will be fenced, but the existing site is as well. To me, the new site is still essentially in the front yard of the residence that's there, and it's adjacent to the highway. So it's going to have minimal impact on foraging opportunities for wildlife. I had some discussions with the Game and Fish because I do have equipment ordered and need somewhere to go with it, and asked if there was any leniency on their April 30th timeline, and they said no. So we are going to adhere to that. But he said from their viewpoint, the large impact is just the sound of the machinery. And by waiting to until the beginning of May, it allows wildlife time to disperse from the valley back up into the mountains, and basically just the populations aren't as condensed and they aren't as stressed by winter conditions, and they're able to move away essentially from any sound caused by the equipment on site.
So in your discussions, then they reassured you that in terms of removing some of the foraging acreage, they didn't see that as a problem.
No, not at all. The grazing, honestly, grazing was never even brought up. This site is, I think, 200 by 217. The slopes will be seeded with native vegetation, and then also, once again, once the existing substation is wrecked out, we are going to reclaim part of that area as well, the part that doesn't encroach upon the driveway of the ranch.
Thank you, Mr. Beckman. I appreciate your answers to the questions, and that's all I have, Mr. Chair.
You're welcome. Thank you.
Mr. Platt?
Yeah, Mr. Beckman, I do have some questions. However, it comes across, I mean to offer them in a friendly spirit, but I do have some concerns about the wetland. And to begin with, did you prepare the summary as part of the carbon power lights presentation, or was it someone else?
I did prepare the summary.
Is the need to replace the substation right now urgent, or just sort of part of the regular planning process looking forward and it's needed but not necessarily urgent? I mean, should it be done within the next year, or would that be a problem, or just as it sits there?
Actually, 2 winters ago, during an outage restoration, that substation was briefly loaded over the current carrying capacity of the transformers. So it, in my mind, is very urgent.
Okay. Well, that's the question. You also already answered one of the other questions I was going to ask about whether or not you looked at other possibilities for other sightings in the nearby area. So I understand that. Did you conduct negotiations with the landowner?
Yes, I did. I worked with, excuse me, what was that?
Were you the person that negotiated with the landowner for the actual selection of the property in the end?
Yes, I sure was. I worked with Ms. Shabali and her brother, Charles Hall, as well, to select the site.
Your sense that they have no flexibility in terms of possibly shifting that site one way or another, or some possibility?
Like I said, I tried to go closer to the driveway. One, they didn't want it obstructing the view of the house that's there. It is the house that is on site it's kind of a shop house, if you will, that they rent out. But I went out and worked to stake corners that were both in a location that I thought would be suitable to them, and obviously there is some low-lying ground. My goal was to stay out of that as well, because obviously we don't want to be in any sort of wetland either. So it was, they were very reluctant to agree to a site to begin with, and I was relieved that they would consent to the site where it's at.
So you did go out there, you looked at the stakes, and the site as staked right now, to your judgment, does not intrude to the wetland. It's all safe land.
No, sir. As I mentioned earlier, the site, I believe the actual dimension is 200 by 217 feet, is in sagebrush, and it's dry.
I have some more questions. I'm going to go from the summary down to the diagrams that Mr. Gertz, I think, prepared. Yeah, I get my computer to go down there. Forgive me. So I'm looking at pages 94, 95, 96. These are diagrams that, again, correct me if I'm wrong, Mr. Gertz prepared, showing an outline of the site that y'all proposed for this use. And my question is, and I'll look at 95, page 95. Do you believe that rectangle accurately reflects the legal description of the site? Not exactly down the inch, whatnot, but is it accurately positioned?
And Mr. Plant, by page numbers, you're talking about pages of the.
Page 95 of the agenda, I'm sorry, of the agenda packet.
PDFs, the actual PDF, I think that's the start.
Okay, yeah, mine, page 95 just says attachment 4. I think it's this one.
Well, I'm
Is it
looking at
the-
page 95,
the wetland
exactly,
one?
exactly this one. It's got a wetland overlay on it.
Should be.
At any rate, maybe Mr. Beckman can answer that question, if you're looking at the same page.
Okay, are we all clear on the question?
Is anyone able to show me the page that you're looking at, since I do not have the actual planning packet?
It's the page that shows aerial imagery with a wetland overlay on it, the general vicinity to include the proposed site.
Excuse me,
It's a
Mr.
purple
Plant,
rectangle.
perhaps. Can you share screen, Mr. Gertz?
You have to give me a second. I'm not logged in on this computer into Zoom right now,
okay.
so, but I could try,
Um,
but it'll be a second.
Well, all right, I just thought that would short circuit it. If Mr. Beckman
I
can
may be able to
elect-
turn my iPad and show you, we'll see.
Yeah, that's the page.
Am I lining it up?
It has the page
Yes,
on your screen.
Mr. Beckman, are you able to answer Mr. Platt's question
I
based
don't know
on
if you
that?
can see it.
Can you see that, Mr. Beckman?
I don't think he
Oh,
can.
no.
I could see it when she was speaking, but now her screen is minimized.
Oh, if I talk, does it show up better then? If I
Yes,
am talking, do I become a screen hog then?
On the way.
Is that? no, then I don't-
I believe the red box is in the vicinity of the location of the site. Yes.
Okay, great.
Okay.
I'm not holding you to that, but I want to know, again, if this is reasonably accurate or not. And I will just say that if it is accurately positioned, it's clear to me that northeast edge of the rectangle of your proposed site does extend into the wetlands. At least it's demarcated by bushes. And maybe some professional expert would say the wetlands extends further out. So I'm concerned about that. And when I look at the schematic for the construction of the site, it looks like nearly the entire site is going to be used for at least a base cover, 90 or 95%. So again, I'm thinking, as it looks to me, and maybe this isn't right, but as it looks to me right here, it looks to me like some portion of wetlands will be disturbed. If I am correct, and Carbon Power and Light goes out there and agree as you're prepared to construct, would you continue with that construction, or would you endeavor to shift that out of the wetland, being a good corporate citizen or cooperative citizen? That's my question. I mean, would you go into this in such a way that it actually intrudes or encroaches into the wetland?
To adjust the footprint of the site, we would certainly have to have further discussions. Oh, excuse me, I changed screens. I'm looking at the wrong camera. Anyhow, we would certainly have to have further discussions with the landowner. We do have the deed filed at the courthouse. So we would have to see what we could make work with the family members that own the ranch.
And do you think there's any possibility, I'm not looking at the construction diagram and schematic, that the footprint could be reduced even slightly, 20 to 30 feet, by shifting the substation location to one side of your site?
So with the design of the site, where the entrance road is to the substation, and is there a chance I could share my screen with the drawing that I'm currently looking at? I don't know.
Can you turn your camera onto it?
Let's see. This is host disabled participant screen.
Here we go.
Yeah, is that making everybody dizzy yet? I apologize. Working with what we have here. Can you see that very well?
Yes, thank you. Yeah, that's great.
Okay, so with the design of the substation, this is the approach in. This is a double gate here and a double gate here, with the idea that a truck is able to drive around the perimeter to once again return this way, because we do have to accommodate two large trucks, one being the truck that delivers the transformer and the other one that delivers the control building, excuse me.
Okay, well, that's great. That answers my question. I don't have any further questions. Mr. Becker, thank you so much for indulging me.
Okay, thank you.
Would have been way sick by now. I hope she's not watching. Okay, so you have Mr. Platt?
That's all I have.
Yeah, given that I think we all have some sympathy for accommodating the recommendations of the Game and Fish Department, Mr. Beckman, looking at the 5 conditions that staff have summarized for us, do you have problems with any of those? And is it clear what I'm talking about?
No, could you please state the conditions?
Does he have a copy of that letter, Mr. Gertz? What?
Is it just, are you talking about the,
I'm looking at your report, Mr. Gertz,
With-
points 1 through 4. Does Mr. Beckman have 5 rather? Does Mr. Beckman have access to that?
What page are you talking about, Bernard?
PDF page 62.
Okay.
Page 2.
the game and fish?
Yeah.
Yes.
Okay.
Specifically.
I do have the letter from the Game and Fish.
Yeah, it's their conditions in there. They have them outlined specifically.
You point Mr. Beckman to the, yeah, I'm reading your summary of the letter, but
Yeah, so in the letter, Jim, under terrestrial conditions, so basically what's in the staff report is every bullet point that's on there. So the no ground disturbing activity or development associated with this project between November 15th and April 30th. And then if you go down to minimize noise or noxious weeds and invasive species, those 3 bullet points. And then under aquatic recommendations, the bullet point about the Corps of Engineers. And then there's 6 bullet points under protect aquatic habitat quality. And then prevented the spread of aquatic invasive species. And then there's, if you get under there, there's 1, 2, 3, 4 bullet points. So all the bullet points are basically what's included in the staff report. So if you've read over those, that's what they're talking about.
Thank you. And then just so we're clear, that the staff recommendation was to include those points in our approval. So I guess the question to try to articulate, Mr. Beckman, is do any of those cause you undue heartburn?
No, sir. Thanks for the clarification. I was aware of those. I wasn't aware that those were the stipulations that you were referring to. But no, that's once again, that's goes with the territory of trying to complete projects in this line of work.
Thank you. That's all I had. Other comments from commissioners? Questions?
None for Mr. Beckman.
For Mr. Beckman, yeah. Okay. Then we'll open this to public comment. Is there anybody? There's nobody here. Anybody online that would like to comment on the conditional use application for carbon power line? Going once, going twice. Hearing none, we'll close the public hearing and move on to commissioner deliberation. Thoughts? We can discuss this before we have a formal motion. What's your pleasure? Mr. Kennedy, you got anything to add?
I am personally very reluctant to add the conditions that Game and Fish asked for, mostly because they did not stay in their wheelhouse at all. And I have worked with USDA, RUS. I actually used to do the vegetation control for a couple other REAs. So I know how thorough they are. And I'm very comfortable with them consulting what they discover with the Corps of Engineers and how they act. I think, and I don't know whether this is something for staff to mention to Game and Fish, but they need to stay in their lane a little bit too, because I know that everybody's kind of knows where they need to go on things, and there's no need for them to be overstepping their bounds on some of these things. And that's my reluctance to go with adherence to all those conditions.
But we did address that concern. I look at condition 3 again. I look at the staff report, which is what has been recommended to us for adoption. It says consultation with the Corps of Engineers, so it may not be within Game and Fish's jurisdiction to talk about wetlands, but they're kind of passing that over to the Corps. So does that address your concern with respect to that?
No, it does not. It certainly doesn't. That is completely out of their wheelhouse, and they don't have any business making comments on whether somebody should consult with the Corps of Engineers, because the lead agency for the Corps in Wyoming, oftentimes people will go through DEQ, and then DEQ will make a determination whether someone needs to go to the Corps of Engineers and or US EPA Region 8 on wetlands determination. So it's people need to stay in their own lane a little bit.
I guess my point would just be that we aren't saying do whatever Game and Fish says. The suggestion for us is to adopt that as a condition by this body, that they consult with Army Corps of Engineers to determine if wetland does in fact exist. So the question before us doesn't get to who gets to play. The question is posed for us, planning and zoning, to make that a condition of this approval. But it's in that spirit that I ask if that satisfies your concern. It leaves us.
I'm much more likely to go with the number 1 on approval rather than approve with conditions.
Okay, other discussion amongst the commission. So go ahead, just be 6 seconds before we leave, Mr. Kennedy. So your preference would be that we approve this without conditions. Am I understanding that right?
That's correct, Mr. Chairman.
Thank you. Other commissioners, Ms. Hanning?
Thank you, Mr. Chair. Well, I guess I support the conditions, especially in light of the potential proximity to the wetlands. One solution, I guess, could be to table this to the next meeting to give the applicant more time to really ascertain whether there are any wetlands there. But I guess I see that Fish and Game, it's sort of hard to say exactly what their lane is because it's all interconnected, and the wetlands are responsible for helping to keep water clean that enters the streams in the aquatic area that they do have the right to care about. So I guess I see it as either supporting the conditions or tabling it for a month to get a little more detail figured out about the existence or lack thereof of the wetlands. But I think that the conditions make sense and that the applicant sounded open to following them. Thanks.
Thank you, Mr. Platt.
Yeah, I'd like to say that I'm generally sympathetic to Carbon Power and Light's position. It strikes me they're in between a rock and a hard place, trying to put this in a good site. Nevertheless, I absolutely believe that no portion of wetlands should be disturbed in the construction of this project or siting of it afterwards. So what I believe should happen is that some qualified professional should be retained to determine where the wetlands are, where they aren't. And compare that with the plot site and make it a condition. I would favor approving this with that condition that wetlands be determined and that no portion of the construction should be allowed to intrude into the wetland. And in fact, I would recommend a buffer strip of perhaps 10 feet of upland dry land in between any disturbed ground and the wetland.
And does condition number 3 address your concerns?
No, I'm thinking in terms of writing our own conditions.
And again, we can do that certainly. It strikes me that condition 3 gets to your question where we would require the applicant to consult with Corps of Engineers to determine if wetland does in fact exist.
I'm saying something different then. I'm saying not necessarily Corps of Engineers. I said some qualified professional, a consultant. Okay. Be fine. As far as I'm concerned, I'm not saying we shouldn't use the Corps of Engineers. I'm just saying it doesn't have to be them. Okay. Someone who knows what they're doing, who can figure out, and we can all agree on, yeah, they know where they're doing. This is where the wetlands are. This is where they aren't. And if it's, I mean, again, I'll just say for Mr. Beckman's sake, who's still listening, that if they should find that it extends well into the proposed site, I'm sympathetic, but I'm also sorry. I mean, we don't have much in the way of wetlands. And we got an awful lot of grazing land. And if that means going out and trying to find some other site, I think that ought to be done rather than build something into a wetland these days.
Thank you. Speaking for myself, I would not be uncomfortable approving it with these conditions, understanding that there's a kind of a cascade. One of the conditions is that Corps of Engineers be brought in as the experts on wetlands. But we may be at an impasse, and we'll have to bring this to a motion here at some point soon. Mr. Gertz, Mr. Beckman, can we bring you back up?
Mr. Chairman.
Yes.
As long as Mr. Beckman's comfortable with number 2, I will go along with that. But I wanted to make the point that I would prefer 1 because I realize that Carbon Power and Light is already and has to consult with the Corps of Engineers. That's a given. if they don't, that endangers all their financing. So they don't have any way around that. So I'm comfortable doing, I'll go along with that so they can go ahead and move on this, but I already gave my objections, so I'll go along with two. So I will make that motion to approve with conditions. Recommend the Board of County Commissioners approve the Carbon Power and Light Herrick Lane conditional use application, adopting and incorporating the staff analysis, findings of fact, and conclusions of laws. Each are stated in this staff report along with the following additional conditions: adherence to the recommendations of the Wyoming Game and Fish Department.
Now, I'm looking over Mr. Ayers, and I think we've beat him down when he looks at those 2 pages. Okay, so if it's satisfactory to council, the motion will be taken to include points 1, 2, 3, 4, and 5 of the staff report. Is that acceptable?
Yes.
I'm asking our legal counsel there just a second.
Would say as the recommendations of the Wyoming Game and Fish Department, as referenced in points 1, 2, 3, 4, and 5 of the staff report, just specify where exactly it is.
Okay. But now, do we have a coherent motion on the floor? Is that what your understanding, Mr. Kennedy? Keith, we lost you?
Yes, I'm comfortable.
Thank you. Is there a second for that motion now that we have a coherent motion?
Hanny will second.
Okay, we have a motion and a second. Further discussion. Kind of had that, but does somebody else want to make any additions to that before we bring it to a vote? Hearing none, are we clear on the motion? I'm looking around, Mr. Kennedy, Ms. Hanning, Mr. Platt. Okay, all in favor of the motion presented by Mr. Kennedy, seconded by Ms. Hanning, please indicate so. Mr. Kennedy.
Aye.
Ms. Hanning.
Aye.
Platt.
Aye.
Mr. Hinckley, aye. Thank you. Next, if somebody needs a break, holler, otherwise we'll move on to the next application. Hearing none. Cottontail subdivision. Oh, and thank you, Mr. Beckman. And you don't need to continue with this fascinating meeting, I'm sure. But thank you for your attendance.
I thank you all for your time, and I'll get to work to make sure all those conditions are met. Thank you and have a good evening.
Thank you.
Thank you.
All right, Cottontail subdivision, preliminary plat SD 1121, staff report from Joe.
All right. The applicant is James Osborne, located at 1 Cottontail Drive. The request is to approve the preliminary plat. Current zoning is urban residential, and access will be from Cottontail Drive, an existing private road. There were a couple of reviews. Karen Bowman, senior GIS analyst, had no concerns. And County Engineer Bill Gorman had some concerns about the preliminary plat, but they were taken care of. Water will be provided by 7 Mile Water District. Sewage will be served by individual septic systems. Those systems will need to be applied for through the county planning department. A storm drainage report was complete for this proposal and reviewed by Bill Gorman, county engineer. Carbon Power and Light provides service to the area. U.S. Postal Service is existing in the area, and the post office will provide service to all new lots. Improvements to Cottontail Drive are proposed. Road maintenance and covenants with the road maintenance plan will need to be filed with the final plat. Financial assurance will also need to be provided with the final plat. Fire protection will be by Albany County. Notice has been provided in accordance with the Albany County Plating and Subdivision Regulations. Chapter 4, Section 9. The information provided in the staff report shall be incorporated as findings of fact. The applicant is proceeding in accordance with the requirements of the Albany County Plating and Subdivision Regulations. And the staff analysis is that this subdivision is being proposed in an already developed area. Preliminary plat complies with the standards of the Albany County Planning and Subdivision Regulations. At the February 1st, 2022 meeting, the Board of County Commissioners approved the variance request from road standards to be able to have a 58-foot right-of-way. Staff recommendation was to approve the preliminary plat for the Cottontail Subdivision Preliminary Plat Application SD 1121 based upon and incorporating the findings of fact and conclusions of law as stated in the staff report. And Jake Schneider is here to represent the applicant.
Thank you. Questions for staff? Mr. Kennedy?
I have none. Give me time to get back to the other screen and unmute.
Ms. Hanning? Questions for staff?
Thank you, Mr. Chair. I have a feeling my questions will be for Mr. Schneider. Thank you.
Platt?
I don't have any.
Yeah, I just had one. I'm a little lost in terms of all of the materials. There's one place that says a site-specific geotechnical analysis should be performed. Was that?
Where are we at?
Well, it's an attachment B now. Maybe that's from the applicant. It could be. I guess that would make most sense. It's had a lot of pieces. All right, let's save that for the applicant, because that wasn't anything that came from you guys.
I don't.
Okay, please. Then let's move on to the applicant, Mr. Snyder. You've got anything to offer, and where do you stand for questions?
Yes, Mr. Chairman.
Thank you.
Okay, Mr. Kennedy.
I have none. Thank you.
Ms. Hanning.
Thank you, Mr. Chair. Thank you, Mr. Schneider. I think you know that I've never liked this project. I was against the zoning down to urban residential. I've always felt that was too small, but I got outvoted on that. So here I am, still disgruntled about this subdivision. So I guess first off, I want to understand where we are with the hookups, the taps in the community, because I thought at the January meeting, you said that maybe after this, there'd only be one more tap left for the whole area, which made me feel a little calmer about how many septic tank leach fields there are out here. But now in reading the report, it sounds like the city has approved 54 taps and there's 45 in existence. So is there anything about these numbers that I'm seeing the potential for several more septic tank leach fields in the future?
Commissioner Hanning, I was not prepared to answer that question, but I know that what we discussed previously has not changed. And I think before I said that there was one tap available through the 7 Mile district because the city is only allowed for so many. And with, you know, we're gonna, there was one tap to this property and there will be 3 additional. So there'll be a total of 4 with this subdivision. And as I understand it, there is still only one more available through the 7 Mile tap agreement or the user agreement with the city of Laramie. I don't know that anything has changed. And then I, in discussions with the city of Laramie, they would be pretty reluctant to allow additional taps to 7 Mile.
Okay, thanks for explaining that. Regarding the stormwater analysis, it says that there was no off-site flows contributing to the stormwater. And I can't help but go back to the letter written by Matt Kay, the adjacent landowner who flood irrigates his ranch land. And it sounds like the potential exists for this land to flood. He sounds like he's not going to change his irrigation practices. So was anything done to look at that flood irrigation and how that could impact and overwhelm the septic tank leach fields?
So to that question, I think that the way that the contours are, everything kind of is parallel, let's say, to the highway. And so if he irrigates to the, directly to the east of the far lot, there could be a little bit that could travel on the corner of that site. But the way that the contours are set, the natural contours and the natural topography is going to lend itself to not allowing much in the, in the way of that. If we could, maybe we could resolve this quite simply by specifying and designing a small berm on the far side, so we could preclude any water from coming this way and divert it where it naturally wants to go, towards the river.
Is there any potential with flood irrigation to be sort of saturating the alluvium from the bottom up, or would it all be top down?
I think, and Vern probably will, and you, I don't know exactly what the geological process of water coming up and going down is, but I know that the general trend of the potentiometric surface out there goes towards the river.
Do you know if the existing house out there has had any complaints with their septic being overwhelmed during irrigation season?
I don't know the answer to that.
And I guess another curiosity, just I noticed one of the outbuildings of that current house is on another one of the new lots. What is the plan for that outbuilding? To just go to the new lot owner? Pretty much goes
well, as
to the
far
parcel?
as I understand it, the James Osborne, the developer, the owner, he's planning on removing everything from the site. All of the existing structures are going to be removed, as far as I understand it.
Okay. I guess that's it for my questions right now. Thanks a lot.
But
I don't have any questions.
all right, I have a concern. One of the things that the applicant had to provide was it's called a Chapter 23 Water Wastewater Suitability Study that's given to DEQ, and DEQ responded with what they call a non-adverse judgment, saying that they had no problem with it. Examination of that modeling finds a conspicuous error in the thickness of the effective aquifer. So the materials brought forward by the applicant suggested that the nitrate concentration groundwater subsequent to development of the proposed septic systems would be 8.6 milligrams per liter, and that compares to a standard of 10. DEQ typically recommends to us that we require enhanced septic systems if that number is over 10. Correction of what I believe to be a straightforward but obvious error would make that number probably 25. In which case, we would not proceed as planned. The difficulty is that, as the applicant has well documented, the shallow aquifer in that area is highly mineralized. It isn't used by anybody for water. That's why they're on the city system. So I'm having this trouble with, I don't think that nitrate is a problem, but I hate to approve something based on bad data. I would like to know whether DEQ gave us a non-adverse recommendation because of that error or because they concluded it didn't matter. So I'm not quite sure what to do at that point, but I hate to go forward with an error. So, Mr. Snyder, you got any reaction to that? I don't know if you've had a chance to discuss this. I called your hydrogeologist, had some communication with her on the point.
Yeah, she talked to me today. Yeah, she told me that you were going to have some pretty tough questions that I probably couldn't answer because I'm not a geologist, and she did a lot of that stuff. And yeah, to your point, and based on what your questions were to her, I mean, you make a valid point. And I guess I have to lean back to DEQ's review and come up to the same conclusion as you. They looked at it and said there was no adverse impact. Is it because the sulfates are well above 1,000, or is it because because we presented data and they don't have any other perhaps data to compare what we're presenting to them? I can't answer instead of DEQ. And I don't exactly know how to answer your question, if there was a question there.
Yeah, well, I guess I'm groping around for a solution. The one that occurred to me is this is a preliminary plat. And I'm looking at Mr. Gurge. Might we go forward with the understanding that we will contact DEQ and ask them why they gave it a non-adverse, and point out to them what we believe is an error, and invite them to give us another opinion? Would that kind of work? Because it really is going to wear down on the design of the septic systems once they go in. So I'm thinking we don't have to address that at this point, assuming that the applicant was happy to go forward, leaving that possibility hanging. Maybe that's back to you, Jake. But if it turned out that DEQ told us we wanted to put in enhanced septic systems, would that alter your design or your enthusiasm for your project?
I'd have to talk to the developer specifically about that, but I don't think that we would have a problem with that.
I'd be happy to reach out to DEQ. However, I don't have the expertise to ask him your questions. So if you provided me something to ask him, then yeah.
That's what I was, well, or I could. I mean, I wouldn't speak for this body without this body's approval, but that would be another option, is if my colleagues would authorize me to contact DEQ on our behalf. I can certainly do that here.
Yeah, I mean, there's no problem asking them why they did what they did.
Should be CC'd on it.
Yeah.
Oh, of course.
Yeah, put us on it. Yeah, I think that'd be appropriate.
Okay, and then as far as leaving that somewhat hanging for the final plat, that would be acceptable.
Yeah, I mean, that could be a condition of this application before we get the final plat, that we figure that out, basically.
Okay. Well, that would be my preference. And I have no other questions for the applicant. Others on the commission want to weigh in on this point? Okay, we will open this to public comments. Are there any public comments on the cocktail application? Going once, going twice. We'll close the public hearing. Commissioner deliberation. I don't know if there's anything more that we want to deliberate before bringing it to a motion, but Mr. Kennedy, have you got anything to add?
I don't, and just so you know, this connection isn't very stable. I had to switch over to my phone, so you get to see me, but my lips might not match the words that come out.
As long as the lips match the brain, we'll call that victory.
After the last month, so would
I. Ms. Hanning.
I guess, Mr. Chair, if you decide to contact DEQ to sort this out, and they agree that the wrong number is being used for the saturated thickness, I guess my question would be whether, it does seem like a bit much to be asking for enhanced septic here, given the quality of the water. but I wonder if the number could be reached with fewer lots, which, you know, gets back to my original concern about having urban residential lots out here instead of small lot residential. Whether you can get to the number you want with fewer septic tank leach fields. Thanks.
Yeah, interesting question. Can we configure a way to move forward that holds that thought? I'm kind of thinking not.
Say that again.
Oh, sorry. Yeah, I wouldn't expect you to do a convoluted condition on that. I'm just sort of talking out loud about how to reach the standard of 10. And, you know, this alluvial water is got to be in contact with the river system. So, I mean, it matters. Thanks.
And let's bear in mind that DEQ does not have the last word on this. They are simply advisory to the county commission. So it's not dispositive what they say. I just want to know what they do say, given proper data. Other thoughts? Okay, I guess where I'm headed would be something like a motion to approve with the condition that we consult with DEQ and retain the option of requiring enhanced septics when we see the final plat. Would that be a coherent way to proceed, Mr. Gerken?
Sure.
Okay, can we have a motion on this topic?
I move to approve with the conditions you just expressed. I'm not gonna go repeat that.
Okay, let me attempt to rephrase the motion. What I hear Mr. Knott saying is a motion to approve the preliminary plat for the Cottontail subdivision SD 1121, incorporating the findings, fact, conclusions, law as presented in staff report, with the condition that Planning and Zoning Commission will contact DEQ regarding the calculation of nitrate concentrations and make a final decision on septic system design when we review the final plat. Does that capture this?
It certainly does.
Is there a second for that motion? Is there a second for that motion? Have we got Mr. Kennedy on the line?
I'll second the motion.
Thank you. Is there further discussion of the motion? I guess I would entertain an amendment that would specifically authorize the chair to contact DEQ to conduct that investigation. Would someone like to make that motion?
Move that we authorize you to contact DEQ.
Is there a second for Mr. Platt's amendment?
Hanning will second.
Is there discussion of the amendment? Hearing none, let's put the amendment to a vote. Mr. Kennedy?
Aye.
Ms. Hanning?
Aye.
Mr. Platt?
Aye.
Hinckley, aye. All right, we're back on the main motion as amended. Further discussion of that motion? And did we get a second? Did we get a second?
Yeah.
Yes, Ms. Hanning seconded. Okay, if there is no further discussion on the main motion, let's put that to a vote. Mr. Kennedy?
No.
Ms. Hanning?
Aye.
Mr. Platt?
Aye.
Hinckley, aye. The motion passes as amended. Are we clear on the motion, Mr. Secretary? You can strip it out of the video or the audio.
I'll watch it again.
All right, one more application before we move on to the second portion of our agenda. If that's acceptable to the crowd, yes? No objection. Thank you, Mr. Snyder. Ladybug subdivision final plat SD 0122. Staff report, Mr. Williams.
All right, the applicant is Susan Faraday, and this is located about 7 miles north of the city of Laramie. The request is to approve of a final plat application and subdivision permit. Current zoning is rural residential, current use is vacant. Lots will be accessed from US Highway 30, and this application will be reviewed as a small subdivision. There were some reviews, most had no concerns. Albany County Engineer Jake Schneider had comments regarding the engineering report final plat, but everything was taken care of. Jory Unverzat, the addressing coordinator, approved the road name, which is Sunflower Court. Laramie Rivers Conservation District, Martin Curry, believes that this is a suitable use for this parcel. He noted that erosion should not be an issue, but care should be taken to minimize land disturbance. He recommends reclaiming disturbed areas and encourages rural small acre landowners to test their well water every 3 to 5 years. And the full comments can be read in the review section. Water will be provided from wells. Sewage will be individual systems, and they will need to be applied for through the Albany County Planning Office. A storm drainage report was complete for this proposal and reviewed by Jake Schneider, the county engineer. Carbon Power and Light provides power to the area. Postal service is existing. There is one new road that required turnaround. It's Sunflower Court and has been approved by the Albany County addressing coordinator. Draft covenants with the road maintenance plan has been submitted. It will need to be filed with the final plat. No financial assurance is required as the turnaround has already been built. Fire protection will be provided by Albany County, and notice has been provided in accordance with Albany County Planning and Subdivision Regulations, Chapter 4, Section 9. Findings of fact, the information provided in the staff report shall be incorporated as findings of fact. Conclusions of law, the applicant is proceeding in accordance with the requirements of the Albany County Planning and Subdivision Regulations. The staff analysis that this application qualifies to be reviewed as a small subdivision in accordance with the Albany County Planning and Subdivision Regulations, Chapter 4, Section 6, and has met the standards of the process. The final plat complies with the Albany County Planning and Subdivision Regulations. This subdivision is being proposed in an area that has been previously developed into a residential community. The lots will be accessed from US Highway 30. The addition of 2 lots should not create any substantial impacts to the area, and fire safety requirements have been waived by the fire warden in accordance with the Albany County Planning and Subdivision Regulations, Chapter 4, Section 6B5. Staff recommends approval of the final plat application and subdivision permit for the Ladybug Ridge subdivision final plat application SD 0122, based upon and incorporating the findings of fact and conclusions of law as stated in the staff report.
Thank you. Questions for staff? Mr. Kennedy. Mr.
I have none.
Thank you. Ms. Hanning?
Thank you, Mr. Chair. I don't have any questions.
Thank you, Mr. Platt.
I don't have any.
One couple small things from me. A teaching moment. Remind us of small subdivisions. What are the special conditions and approval procedures for small subdivisions?
So they have to be 3 lots or less. They don't have to put notice in the paper that they are planning on subdividing.
Have to do a DEQ.
Don't have to do a DEQ report. That's about it. The fire warden can waive the safety requirement or the fire requirement.
In your under road maintenance, you write it will need to be filed with the final plat, but this is the final plat. So
Yep. So if it gets approved, they'll have to give us a Mylar, which is what you signed for that one. And it'll have to be filed with the clerk, and that's when they'll file the covenants and with the road maintenance agreement.
So that isn't a condition or an unmet requirement. That's just advised to us that that's.
Yep.
Okay, I understand. Thank you.
And they've already submitted that. That's with it's in the application.
Okay. All right, thank you. That's all I had. Would the applicant like to comment, and would anyone on the commission like to question them?
No, just thank you.
Thank you for your patience. It's a multi-step process, but it looks like a nice little project. So
Yes.
appreciate your following along. If there are no questions for the applicant, are there public comments? Anyone like to offer a public comment on the Ladybug subdivision? Hearing none, we'll close the public hearing. Commissioners, what's your pleasure? Further thoughts?
I'm perfectly fine with this.
So we need a motion following our staff reports, pros ideally. Everybody?
The pros coming from the script or from the agenda?
Should be the same, should be on the, I think the agenda.
I'm not saying it on the agenda. I'm just,
Mr. Chairman.
I'm not saying it's not there.
I'm sorry, Mr. Kennedy?
I do have it in front of me. Mr. Chairman, I recommend move to recommend approval of the Ladybug Ridge subdivision application, final plat SD-01-22 to the Board of County Commissioners incorporating the findings of fact and conclusions of law as listed in the staff report.
Is there a second?
I second.
Second for Mr. Platt. Is there further discussion? Hearing none. Mr. Kennedy, how do you vote?
Aye.
Ms. Hanning?
Aye.
Mr. Platt?
Aye.
Hinckley, aye. Motion carries. Thank you, folks, for your patience. Good luck with your subdivision. We'll look forward to seeing it as we drive by. I would suggest we take a short break at this point before continuing our agenda. Is that acceptable to my colleagues?
Yes.
What, 5 minutes? Oh, okay, let's try to reconvene at 6:56-ish. Okay, we are in recess. Thank you. Okay, I guess we're all. Mr. Kennedy, are you back with us?
I never left my room.
Never left, okay. All right, let us move on through the agenda. We've got a couple of things that are fairly short and one major piece that I appreciate everyone's patience for, but that we're trying to do the county's business in a responsible way. Current planning projects. First of that is a CAP update, Mr. Gertch.
All right, so the Casper Aquifer Protection Plan is currently being updated with the consulting firm, Stantec. They're doing a lot of work. They've collected all of our reports and information they have. They're looking at the western boundary. I think they're actually looking at the southern and northern boundaries of the Casper Aquifer, just getting data and looking at those. They're making revisions or beginning their revisions on the actual document. And so we actually have a meeting tomorrow. We'll get a better update on where they're at and what they're doing. So, but right now it's with the consultant. They're just doing all the technical work, doing an analysis of the data that we have and putting some of that information together.
So they're, as far as you can tell, on track on budget for proceeding.
I think so, yeah.
Thank you. Questions for Mr. Gertch from anybody on the CAP update? Hearing none. Item 2, the GAMP, one of our consultants coined that acronym, Growth Area Management Plan. Where are we on that?
So we've hired a consultant. Hired Logan Simpson. I was like, what are those? Anyways, Logan Simpson to do this. They began, right now they're putting together the public, what do you call it? Public plan or whatever to gather input. And they'll be presenting that to us here later. They're planning. Staff has actually met with them once just to kind of go over how this is all going to work, coordination. But really, we're at the beginning stages of it, just getting organized and starting to move forward. But they need a lot of this stuff kind of approved to go forward. We've got such a small window of time to get this done. We're supposed to have this done in October. A plan like this would typically take longer than that, but we've been limited. So yeah, I feel like we're going to get a good product and we're going to get a lot of public participation opportunities. And so yeah, that's kind of where we're at. It's organizing. So
I completely agree that the schedule is quite ambitious, but that was decided by our elected officials.
Yep.
And we do as we're instructed. Questions, comments from the commissioners on that project? Okay, we'll look forward to see it. So good results. And it really is a wonderful example of the cooperative spirit between the city and the county. It is a management plan that both entities are fully participating in, and therefore should eliminate, to the extent we can, conflicts down the road. Okay, third item, zoning resolution review, and let me make a few remarks here, and then Mr. Gertch can present his materials. For my colleagues, one of my goals for this year is to prepare revisions of the zoning resolution for the board to consider. And this was brought to our attention last fall, and we discussed a little bit in our training session last month. I think some of you may have felt like you got dumped in the middle of a stream that had been flowing for quite some time, and that was in fact the case. Just to give a quick overview for the record, the current zoning resolution was deemed to be problematic with some recent changes in state statute with respect to how and if the comp plan can be used in making zoning decisions. This was what Mr. Platt was referring to earlier. And the council brought that to our attention. The commission certainly was interested in making our zoning resolution comply with state law, which we're basically compelled to do, but I think there was sympathy for continuing to use the comp plan in some form to make zoning decisions. So we were faced with, all right, how do we, one, comply with state law, two, recognize our mutual interest in using the comp plan? At this point, there have been three general ideas thrown out. We're not going to discuss and go through all those today, but just to get us up to speed, and this will be something we'll continue discussions on in subsequent meetings. The first, which was reflected in some of the staff reports in the last couple of months, was simply to delete any reference to the comp plan in the zoning regulation. That would be a quick fix. It fails to meet that second criteria of we think it is appropriate. Maybe I'm speaking for myself. I think it's appropriate that the comp plan guide zoning decisions. That's why you do a comp plan. The invitation in the state statute is to incorporate comp plan elements into the zoning regulations. And Mr. Ayers has suggested some ideas of how we might do that. A third alternative, which is the one that I guess I'll attach my name to just to give it a moniker, was to consider zoning changes the same way we do zoning in the first place, as a change to the regulations. Because certainly there's no prohibition on using the comp plan to make zoning decisions. In fact, that is invited and specifically authorized in statute. So to move that discussion forward in increment, we'll just bank this for future use, I'd ask staff to just give us a quick look at what the procedural difference is between the current system, which is to make a zoning change at the instigation of a landlord comes to us, says, I want to change from commercial to rural residential, and we consider it, and then if we approve it, we'll send it up to the county commission and it'll go forward. If we were doing it as a change in the regulations, it's a slightly, that process is controlled by the Administrative Procedures Act and is arguably somewhat more cumbersome. So with that long preface, thank you for your patience, Mr. Gertz. He has prepared us a short memo that addresses that specific point of what is the procedural difference both in time and commitment of resources on our part of the county and the part of the applicant to amend the zoning resolution versus basically the current system in which we would have accommodated the comp plan in some other manner. Okay.
Yeah.
Fair enough.
Yep. Thank you, Mr. Chairman. So just to do a quick comparison, we're going to compare a zoning change, what's the process in our regulations, to just a regulation amendment process. So the zone change, it's a process you guys are familiar with. Planning office receives an application, comes to you guys for review, and then it goes to the board for we make a recommendation to you, you guys make a recommendation to the board, and the board makes a decision. So that's kind of the base process. The difference between that process and the process of amending regulation would be that we add kind of one more meeting in there with the Board of County Commissioners. Anytime we make changes to their regulations, they have to direct us to publish that and set a public hearing for that meeting, instead of it just kind of all being part of the process when we go through the zone change process. So procedurally, there's one more meeting. So just to outline it, it starts somewhere, which is usually staff, or it could be you, or it could be somebody else that requests a regulation amendment, comes to planning and zoning for recommendation. And then once you make a recommendation, we go to the board and we say, hey, okay, we've got this recommendation for planning and zoning. We would like to receive your directive to publish and schedule a hearing date. And so we do that, and then we come back one more time during that hearing, and they can make a decision at that time after they've had that public hearing. So you had a meeting. Timeline wise, so once you receive a zoning change application, you're looking at about 45 days between the time we get it and the time it gets on the Planning and Zoning Commission agenda. And that gives time for us to get out reviews to other agencies to look at, and then get those reviews back, as well as just coming up with our staff report and making a determination of what our staff opinion is going to be on the project. It comes to you guys. at the end of that 45 days. Typically, there's about a month, probably 3 weeks or so, 3 weeks to a month, 3 or 4 weeks to get it on the Board of County Commissioners meeting. Once it gets there, the hearing's already been published with everything else, and they have their public hearing, they can get it done. So that takes about 75 to 90 days, just dependent on what happens. But the quickest is about 75 days. On the other hand, so the timeline for a amendment to our regulations, you're looking at 30 days to get on the Planning and Zoning Commission agenda. This is we're assuming this is a pretty easy amendment, and we're not amending the whole thing because that could take years. So, which has, but for other things, but say we're just looking at something with I don't know, short-term rentals or whatever, that always seems to come up in our office. So we prepare an amendment. It takes us maybe a month to do that, just with everything else that's going on, and get it on your agenda. You guys will look at it and then make a recommendation or fiddle with it or whatever we want to do. And that could take a long time depending on how complicated it is. But if we're just going forward, we get that going forward. And then about 30 days later, we go and get the directive to publish. And then it's 45 days that we have to have it published. But by the time we can get it in the papers, you're looking at 50 plus days, pretty much to hold a public hearing. And then we come back. And so the total process time is between 110 days plus. That's what we're kind of looking at on that end. And then the last thing, staff time, I kind of put 5 to 15 hours, but it really depends on what for a zoning application, that's probably correct. But like, depending on what the amendment is, it could take us a lot of time depending on what kind of research we have to do. So I don't know if that's even relevant to this discussion, but notice requirements. So the notice requirements for zone change, everybody or anybody that comes in for an application, they post a sign, they send certified letters, which the cost is borne by the applicant. The county publishes notice in the paper. However, we do collect a fee to take care of the notice. So really, there's no cost to the county. If we were to just do a amendment to the regulations, then we still have to publish in the paper. There's no signposts anywhere because it's not a specific property. And we have to do 45 days notice before the meeting. And then we publish or put it in the paper. And that would cost the county, $50 to $100. We don't get reimbursed for that when we are making an amendment. So that's kind of the differences. So you're looking at a little bit more time on if we go through the amendment process with the extra meeting to direct us to publish, as well as the 45-day period to, for the notice before the Board of County Commissioners meeting. So it's a little bit longer. There's the fee that we have to take care of as the county or whatever, and where the zoning change process doesn't do that. And I think the discussion is I think this is where you're coming from, is like, well, do we change the zoning change process to be like a regulation amendment process and just follow that? So, if we did, then we would collect the fee, and so there would be a wash on the fee for the notice fee. So, but I'm just pointing out how we do it right now. So anyways, that's kind of in a nutshell, the differences in the process. To me, there's not a whole lot difference, maybe a little bit more time. And not a whole lot. Yeah. I guess there's any questions on those processes, or you want clarification on that?
That's exactly what I was looking to have you explain to us.
Okay.
And so, the paradigm in my mind is if something comes to us where someone wants to say, I want to go from, let's take Miss Powell's agricultural to ultimately it was small lot residential. If we all said, yeah, that's great, it's consistent with our private growth areas, we're all in favor of it, if we were to proceed as that changes the zoning through the zoning map versus saying, sure, that's a zoning change, go for it. That would be the difference. Now, those two would stray if there was a lot of controversy. But my sense is that that's good. If somebody was really opposed to it, then it should be exposed to a wider public comment. So no, that's exactly what I was looking for. And again, we will be back to this if there are other comments at this point that someone wants to make. But
Well, I have comments about this, which I was going to offer later, but it pertains to this.
well, no, let's go ahead. But again, remember this larger discussion will continue in subsequent meetings. So this is just
And my comments are directed at the problem we have right now with incorporating the comprehensive plan as is written into the zoning resolution and addressing it through inserting some legal text or striking certain provisions or findings from the process. And what I think should happen, I do not think we should be doing what we're doing right now. We're on an ad hoc basis, we're inserting some text or striking findings unless it comes before this commission as a recommendation, we should do it. And we approve it. Not y'all. I don't say that unfriendly, but I think we should be approving it and it should be done by vote as a matter of public record. And what I propose we do is in the interim, until we actually hopefully arrive one day at a long-term solution, is that we apply the zoning resolution exactly as written for the finding sections, for conditional uses and for zoning change requests. And we do all the things, collecting all the information, including the parts that pertain to the comprehensive plan for the applicants. And then as part of your staff analysis, you go to Matt and say, do you have a problem with this? With what the applicant has supplied. And if you do have a problem, you prepare a recommendation for what we should do. We should strike that element, or we should caution that this information cannot be used as a basis of denial, whatever. But again, I think for the time being, we should use the zoning resolution exactly as it's written, which does incorporate the comprehensive plan to at least some degree. And if a legal problem arises, you identify that, provide a recommendation as part of the staff report, and we consider that recommendation, and we either do what you say we should do or we don't. And that's why I suggest we do, again, in the interim going forward. It actually doesn't require any action unless someone here violently disagrees. No, because we're just following the zoning resolution as written.
Okay, thank you for that comment. Others, I'm prepared to defer the discussion until somewhat later. And as we discussed earlier, I would take the council to have been, sure, leave it in, but if you're going to deny something, give us some other reasons in addition, just as good advice from council. But anyway, unless somebody wants to pursue this further now.
I'll just add one other comment. I don't doubt anyone's good intentions here.
Sure.
Absolutely not.
Okay, thank you, Mr. Kurtz. That's just exactly what I thought I was looking for. One little stepping stone, moving that discussion forward and to be continued. If there are no objections, we'll move on to item 4 on current planning projects versus natural resources management plan. Thank you all for.
Yes, sir. We added 3B.
Oh, I'm sorry. Yes, good. Subdivisions. Mr. Kennedy, what would you like to bring to our attention with respect to modification of the subdivision regulations? Keith, you with us?
Yes, I'm with you. What I had talked with David about after our last meeting was adopting rules and procedures. And I had actually looked at carbon counties. And when I had asked about ours, they actually predate the current state statute numbering system. They were done in the 70s, and they don't even reflect current statute. And I'd recommend that we at least take a look at the Carbon County rules and procedures that their planning and zoning uses, which are readily available on their website, and and perhaps look at those next month and make any suggested changes beyond obvious language changes for where we are, and then move forward to go ahead and adopt those, just to get those updated rather than being something that's pushing at least 45 years old.
I think our bylaws are similarly ancient. Mr. Ayers, if you'd like to speak to that.
Not to that, Mr. Chair. I had an update on the subdivision resolution updates, which I believe was the number 3B.
Yeah, I guess that's what I thought. Mr. Kennedy had made that addition to our agenda. He did.
No, Mr. Chairman, I had asked for that addition on the rules and procedures, so.
Oh, okay.
I think we asked for it, and then Mr. Kennedy was okay with that.
All right. Well, however we got here, here's where we are, Mr. Harris.
Okay. So I had begun. Okay, where to start? Historically, I believe it was December of 2020. There was discussions about formally splitting the review process between the preliminary plat and final plat for subdivision reviews. Currently in our regulations, it seems to be that they are to be, it reads that they are to be considered concurrently together as part of an application. I've been looking over this for the past week or so, and I have concerns about how it will impact state statute as far as the timelines if we were to split those up. The triggering, I guess, yeah, the triggering event is the submission of a subdivision permit application, which then gives this commission 45 days to make a decision, and then the board has 45 days to either issue a permit or a ruling. By splitting those up, I am concerned that we could run afoul of those timelines. There is there's a provision in 185315 where counties can impose more restrictive requirements upon subdivision permit applicants. My concern is that those requirements aren't procedural. But it is true that almost every county in Wyoming does have a split process. So I have reached out to my colleagues in other counties to ask for their opinions on the matter. And other than that, we also have been working on just cleaning things up, nothing substantive. We do have a few recommendations from Mr. Gerch. And in addition, just structurally, the subdivision resolution is duplicative. It has, it says the same things in a few different places. So just kind of structurally how to get that a little cleaner. And so that has kind of been my focus recently now that I have been able to divert my attention back to it. And I would welcome any sort of substantive policy recommendations from any members of this commission, where you think that might fit, what that language might look like, and we would be happy to incorporate those. I think otherwise we're going to try and get something out within the next few months or as time permits, just based off of these this round of revisions. But I'm sure it will be a ongoing process, as with most.
And thank you. I extended an invitation to all of our members as we come up to speed with the regulations, flag things that, and it's not heavy criticism of our predecessors, but baggage accumulates over the years.
Absolutely.
Our bylaws are passed in 74, 84, something.
Yes, I think 74.
Yeah, so it's perfectly appropriate that every 20 or 30 years, we take a deep breath and see where we are. So I think that's certainly a good suggestion. To make it best for us, if there are some specific issues that you feel like you need guidance on, cue those up in a little memo or something, and then we can kind of tick through them at a subsequent meeting.
And I think once I understand where counties are coming from legally, as far as that process, I will have, I've done a full review of how every other county in Wyoming does it, and there's a myriad of different ways you can do it. So, but that might be better reserved for a work session.
Yeah, let's comments from the commissioners are fine, but my sense is that this is something we want to just move forward with as best we can, whether we fit it into meetings or a work session. I think it'd be fine.
I think once we get to the point where we're ready for that, we can schedule something, or let you know, and you guys can decide how you want to do it.
But any commissioners who want to feed into this process, because again, things that have caught your eye, I think as we all read them, we see the same things Matt is, just stylistically, organizationally. So let's clean those up. It makes it easier for us, and it certainly makes it easier for our applicants to understand what our rules are. So thank you. Further discussion of our resolution updates. Okay. David put the next item on the agenda as discussion, I think was the word you used, of the resource management plan that's been underway for some 6 months now. So I'm not sure how we're going to go through this. Do you have a presentation? Does our consultant have a presentation?
Our consultant has a presentation.
And how long is that?
I think for it was just like a couple hours or something.
Oh, yeah, all right. Well,
no, I think it was like 10.
We get it done by tomorrow.
But so why don't I go ahead and just introduce everybody, if that's okay?
Sure. I just wondered how we're going to do this and allocating our time. So let's just wade in.
Sure.
Thank you.
Okay. So we have our consultants on board with us. We have Bree from Y2 Consulting. She's there with us in Zoom land, and then Connor Nicholas is also on there. He's the phone symbol right there. Looks just like him. So those are our consultants. Those are the ones that have been kind of running us through this process. We've also have many of our steering committee members. I think all of us, about maybe one. Till Wyckoff, she's on with us. Mike Massey. Bonnie Bath, Joe and myself, and Laura Hemming. So that was our committee. We had the director, or the interim director from Laramie Rivers Conservation District as well, but he's not with us tonight. But he's been a part of this process as well. So that's introductions of who's been really looking at this and going through this process. So I'll turn the time over to Bree. Do you need me to allow you to share your screen?
Yeah, that would be great. I have a PowerPoint.
I think I figured out how to do it, so.
Excellent. We'll only go till midnight. It'll be okay.
Everybody starts looking orange like they're going to turn into a pumpkin, we'll rescue them.
Okay, I made you a co-host. You should be able to share your screen.
Yep, we are good to go. Now I just gotta find which screen it wants to share. Give me just a second. Why are you not showing up? There we go. Great. So I'm going to do the presentation, but Connor is also on the phone and may chime in a couple spots as we go through this. But the lovely winter storm has knocked down his internet, so that's why you get the phone symbol for Connor. But thank you, Mr. Chairman and the Commission for letting us present kind of on what we've been up to with the Natural Resource Management Plan for Albany County the last about 6 months. We're really excited about where we're at, and really, we've kind of we've put the meat on the bones, but now we're really getting into the public participation and the public comment for this plan now that we have this draft. So really excited through that. So the presentation tonight is just going to go through a little bit of what a natural resource management plan is, how it's used to interact with the federal agencies, and then just a little bit about the process that we have used up to this point to kind of develop that draft. So first of all, it's really kind of essential to determine what a county resource management plan is and what it is not. And it's a little easier to define what it is not first. And what it's not is zoning or regulations that traditionally are seen adopted by counties. You guys have been talking about that a lot tonight. It's also not a plan that requires federal managers to take specific actions. So local governments do not have jurisdiction over the federal government. And for example, this plan, cannot dictate to the BLM how many grazing AUMs will be allocated for a given area. So those are what it does not do. What it does do, it's a plan that ensures that federal decisions consider relevant data and information that impacts local resources and the economy. So really impacts, Albany County. It's also a tool that informs federal agencies on what issues Albany County wants to be a cooperating agency for. And it's a tool that can be used to influence local federal decisions through consistency review and coordination, which we'll go into depth here. So why would Albany County want to adopt a resource management plan? So federal statute give local governments the ability to substantially influence federal decisions and specifically interact with federal agencies beyond those that are available to just the general public. And those come in the form of the 3 C's, which we'll go into in depth, but those are consistency review, coordination, and cooperating agency status. And understanding and using these processes, furthers the statutory mandates of Wyoming counties to protect the health, safety, and welfare of their constituents. So we'll kind of dive into the 3 C's. The first being consistency review. And consistency review requires a federal agency to review plans, policies, or laws adopted by a local government and explain why there are differences between that federal government's action and the local plan, policy, or law. Consistency review is a powerful tool. It ensures that local voices are heard and considered, so not just heard, but that they are considered during the decision-making process. Consistency review comes up in NEPA, or the National Environmental Policy Act. A federal agency must discuss inconsistencies, kind of as we talked about, between the proposed federal action and any approved state or local plan. And where there is an inconsistency, the document needs to describe the extent to which the agency would reconcile its proposed action with the local plan or law. All major federal actions typically undergo NEPA analysis. We found that, some courts have said that when the federal government spends any amount of money, and for almost every federal decision, that NEPA compliance is required.
One thing I'd like to add, Bree, with that, this is Connor Nicholas over at Bud Fallon, is one of the things I think is valuable with consistency review when we're looking at NEPA is while it doesn't require that the agency be consistent with these natural resource management plans, what it does ask is that the agency show where it can be consistent, or how it's going to try to reconcile itself with the plan. And by having it have to undergo that process and exercise of, okay, this is how we're going to try to reconcile with the plan. It's kind of like when you kind of have to give them homework. Sometimes it's easier just to try to be consistent with the plan itself, rather than try to devise ways as to why you won't be consistent. And so that is really kind of why it's valuable. While we can't dictate exactly what we would want to do to the federal agencies, we don't have that power. What it really does is it really brings in almost I would say a partnership where let's try to be consistent where possible, and let's meet those consistencies where we can.
Thanks, Connor. So consistency review also is in FLPMA, or the Federal Land Management Policy Act. It requires consistency review. And so FLPMA is a federal law that gives BLM its power and its direction. And BLM land use plans shall be consistent with state and local plans to the maximum extent consistent with federal law and the purposes of FLPMA. So the second C in our, oh,
sorry,
go ahead, Connor.
I was going to say, and now it's good to point out just the difference between NEPA's consistency review and FLPMA's is that it does make consistency review mandatory for the BLM, and that it shall be consistent wherever possible. And I think that the shall, as many of you know, once again makes it a mandatory thing. And now it's kind of shifted to when the agency is inconsistent with the plan, and I'm talking BLM, what they need to show then is where in federal law does it require for them to be inconsistent with the plan. And so what FLPMA really does is it takes that extra step, that next step beyond what NEPA requires. And now instead of saying, okay, this is how we'll try to reconcile the plans like NEPA requires, FLPMA says, okay, we will be consistent with this plan unless we can point out to a specific law or something within FLPMA itself, law or regulation, that says we cannot be consistent with the plan as a whole. It's once again just a really powerful tool.
So then moving into our second C in our 3 Cs is cooperating agency status. And this gives local government the ability to participate as part of an agency decision-making process. There are some things that a cooperating agency must be. They must be both a locally elected body, so something such as, the county commissioners, and they must possess special expertise. And special expertise is defined as the authority granted to a local governing body by state statute. And that's defined, as Wyoming County Commissioners, defined in Wyoming state statutes, that they're authorized to participate as cooperating agencies and have the special expertise regarding the health, safety, welfare, custom, culture, and socioeconomic viability of the county. And lastly,
I think it's important to, sorry.
Go for it.
Real quick, Britt. I think it's important to note that these plans, cooperating agency status doesn't require that you have a natural resource management plan. However, what natural resource management plan really can help with and assist with, and when it comes to cooperating agency status, is it can basically provide notice to the agency, hey, these are things we as a county really care about. We really care about, let's say, clean water. And whenever you have, as an agency, are being involved in clean water actions or regulations that might affect Albany County, we as a county want to be able to have the choice, and it's not mandatory, but to have a choice to try to participate at the earliest time possible. And so while this plan isn't necessarily required to be a cooperating agency, where this plan can really assist is it provides those agencies notice, and it also provides quite a bit of assistance to county personnel as to what are these policies we have right now and what are the goals we're trying to attain, which can help quite a bit when it comes to doing a lot of the work as when you're on the ID team or anything else with as a cooperating agency.
Great. So the last C in our 3 Cs is coordination. And the first that we'll discuss is BLM coordination. So FLPMA gives 4 requirements for coordinating with a local land use plan. The first is that BLM must stay apprised of local land use plans. The second is that the BLM must assure that local land use plans are relevant to the development of BLM land use plans. or relevant to the development of BLM land use plans are given consideration. The third is that to the extent practical, the BLM must assist in resolving inconsistencies between local and BLM land use plans. And the last one is that BLM must provide for the meaningful involvement of local governments in the development of BLM land use program regulations and decisions. So this includes early notification of proposed decisions that may impact both federal and non-federal lands within the county. Anything
and I think that last, yeah, sorry, I think that the last point there of that early notification and just involvement of the county, that's really the most valuable part of coordination as a whole. Just to be able to have those informal conversations between the agency and the government agencies, and really to make sure what coordination, the spirit of coordination really is that there's no surprises that happen to the county. When the agencies are planning on an action, the county as a whole should be really informed as to what's going on and be given the opportunity to participate and also not just through a formal cooperating agency, but just having those informal conversations is invaluable, and that's what coordination really is supporting. And where this plan kind of comes into play with that is once again it puts the agencies on notice of these are things that we are particularly want to be coordinated with. We want to be coordinated with whenever there is a new, let's say, a new federal lease, new federal mineral lease in the area. We want to be particularly coordinated with and have early discussions as soon as possible if we have critical habitat designation possibilities in the area. And what coordination does and why it's so related to this plan is, once again, the agency is now being given notice of, hey, these are things that are important to the county, and these are things we'd like to be just really involved with at the earliest time possible.
Could I make a request that we have Bree go
Yes.
through her presentation and then we could all jump in?
Yeah.
Most certainly. I apologize. It's we do this presentation typically together, and so that's how we were flying through it. So I apologize for that.
Yeah, so I'll just move through the rest of these. There's just a few more, and then we can have the discussion. So Forest Service also requires coordination through the National Forest Management Act. The Forest Service must develop, maintain, and revise land and resource management plans that are coordinated with the land and resource management planning processes of local governments. Coordination with the Forest Service means more than simply considering the plan. They must attempt to achieve compatibility between a Forest Service plan and local land use plans. So really, what's the moral of the story kind of with these, the 3 Cs and the natural resource plans with the federal agencies? So federal statutes have given local governments a voice in federal decisions that affect local resources. Consistency review is required for all major federal actions. Cooperating agency status is granted to all local governments who have special expertise. And both the BLM and Forest Service are specifically required to coordinate with local land use plans under FLPMA for BLM and under the National Forest Management Act, or NIFMA, for the Forest Service. And so really having a natural resource management plan lays out local land use policy and is a way to ensure that the county can really utilize these federal statutes and guarantee that the county's voice is heard and considered. So the second part, which is going to go really quick, is just the process up to this point for development of the draft natural resource management plan. So we started in August of 2021. We held a public scoping meeting that was held in Laramie in mid-August. It was at the county library. We did have people that attended that. It was had some really good feedback from that. We then started drafting the documents with the steering committee, who David introduced, and I also have a slide on here. And we've been developing that since August and kind of finished up the draft in early February that we were then able to provide. So then right now we're looking at, reviewing this with the planning and zoning tonight. And then we are reviewing with the county commissioners next Tuesday. And then once we go through that and incorporate kind of any of these final edits here, the document will go out for a 30-day public comment period. Tentatively, it's scheduled to go out on March 23rd. That could get pushed a day or two here or there, depending on what we need to incorporate. That will be a 30-day public comment period where it will be open for public comments. And there is a public meeting scheduled for that. Tentatively, that's scheduled for April 7th, but that'll get solidified here in the next week or so, and that's to be in Laramie. And then we have a deadline of May to have that final document submitted to the Albany County Commissioners for their consideration for adoption. So this is just our steering committee. David introduced everyone. I think the only one missing tonight is Martin from Laramie Rivers Conservation District. I just want to express our thanks to the steering committee. They have really been the developers of this document. Connor and I have just been kind of helping the process move forward and keep us on time and on track. But the steering committee has been amazing and really has represented the county. And so I just want to thank them all for their time in this. We've spent a lot of hours on Zoom calls putting this together. So I'll be glad to come down for the public meeting in April and hopefully see everybody, maybe in person, because I feel like we spent a lot of time on Zoom. But so that's been our steering committee. And then just next steps, which again, we've kind of already discussed, we're reviewing the document with planning and zoning and county commissioners this week and next week. Then it will be released for that 30-day public comment period. We are asking that all comments are provided in writing or handwritten and then submitted to designated locations. We have an email set up for this project. And then I think I still need to talk with David, but I think, comments could maybe be submitted to the planning or if the county clerk's office. We'll figure out those details in the next couple weeks. Once that public comment period closes, we'll analyze the public comments and review with steering committee and the commissioners and incorporate into the document. And all the comments received during the official public comment period will be placed as in the appendix of the document. So, and then once we have that, we'll provide the final document to the steering committee and the Board of County Commissioners for final review and consideration for adoption by the middle of May. So with that, that's what I had for a brief presentation. I'm going to stop sharing now. And I think, David, however you want to run this, but we can open it up for a discussion or questions, or if the steering committee wants to add anything, I'd let them add anything they would like to. And I think you're muted, David.
Sorry, I fixed our feedback problem though, so. Anyways, so yeah, I think if it's okay, we'll just hear anything from the steering committee that they would like to add, and then Chairman, you can go ahead and just ask questions, make comments, get into the document wherever we want to go. If that works for everybody.
Sure, let's hear from steering committee if they have something to add. If not, that's fine too.
Mr. Chairman? Yeah.
Go ahead.
Yeah, this is Mike. I'll get my photograph up there, I guess. Start video. Is that the right one? Yeah, there we are.
There you go. Whoa.
Yeah, this is about as tech savvy as I get. Just wanted to add to the presentation of Bree and to Connor's comments. I think it's easy to kind of get bogged down in the legal mechanisms and background of this natural resource management plan. And certainly that's important. I don't want to diminish that. But I think that there's a basic principle that's a little bit more important that that we need to keep our eye on and keep asking ourselves to make sure that this effort is worth it. And that is what we're really after, I think, and this is just my opinion, is to have a constructive dialogue between our county commissioners and the folks who manage our federal public lands in Albany County. And hopefully this document will foster that constructive dialogue. And I think the important elements for folks to really keep in mind or to focus on in this document, which is over 100 pages long, but to really focus on these three things. The first one are what we consider the priority uses of these public lands that reflect our custom and culture here in Albany County. In a nutshell, as you go through the document, you'll find that those are agriculture, clean air and water, renewable energy, recreation, and wildlife. Now, mining and gathering of wood or industrial timber development are not on that list, but it's still important to remember that some folks in Albany County depend upon mining, especially the rock quarry up Rogers Canyon and the folks at the cement plant. And wood is still important too. Post operations here in the county, gathering of firewood for personal use, and certainly just basic management of the forest, make sure it's a healthy ecosystem. So those are important as well. And then the second and third things are the objectives and priorities. There's a lot of narrative in here, but if folks were just to look at the objectives and priorities, then that's what the county is telling the federal government, what we think is important, and that's what we want to talk about. So the legal stuff's important, but I think that we also have to keep in mind, is this going to be a constructive effort and worth our county commissioners' time as well as the federal management agencies? So thank you.
Thank you. Anybody else on the steering committee want to weigh in before we dive in? Okay. I'm a little unclear on just how this proceeds. Are we making comments? Do you want those in writing, Bree, as you suggested, for the public? Is somebody being described for tonight? What are your goals? I guess I'm directing that to either Mr. Gertz or Bree. What are we doing here? We're not making a decision on anything. Is that correct?
Right.
You're asking us for approval or denial or approval with conditions. Okay.
Yeah. So I mean, if you have written comments, that would be amazing, I believe. But we can also jot down what the comments. I don't know what are your thoughts, Bree?
Yeah, I think if you have comments that are already written and you just want to get those to David and then he can get those to me, that's the easiest. But if there's things that we want that we need to discuss or edits we need to put in this evening, I can just scribe in the document and then incorporate those later. So either works or a mixture of the two. I would say if you've already kind of gone through and put your comments in, it might just be easier to, get those to David and he can get those to us and we can get them incorporated. But if we want to discuss anything, I'm more than happy to scribe and have those discussions. So.
Thank you. And I don't know what my colleagues have done. I've been following this with some concern, care, and so I've spent a couple of days looking at it. And I had comments for this meeting that I grouped between sort of procedural and purpose, and then some comments on the general scope of the whole thing and how it's organized, whether you've captured the things that I was looking for. And then I'm sure we all have a lot of little comments. Do we agree with the statement on such and such under item number 17? I'm guessing that's probably more detailed than any of us have patience for tonight. Mara, Keith, Michael, how do you want to proceed? I've got quite a bit of material that can organize those two big
Well, I have a
groups.
simple comment I can make.
Okay, go ahead.
This applies for me. To the steering committee, since you're all there and our consultants, I believe that the importance of recreation has been underemphasized. And I think going forward in our future, recreation will only become more important relative to other natural resource uses as compared to today. So I would like to see more emphasis put on that and a higher priority given to those objectives there. That's all.
Were you intending to provide, again, I don't want a big assignment there, but it's a 160-page document, that steering committee. I guess I would start right out. Total thanks to you guys. They've done a terrific job. I confess I was a little skeptical of this project going in just because I looked at some of the other counties and did not feel like they really represented Albany County very well, but I right up front, for all the comments that you're going to hear from us and the subsequent public, don't think for a minute, you steering committee members, that your efforts weren't appreciated and you've obviously brought a lot of good work to this and turned it into a lot more of an Albany County document than just a generic document that one might have done a search and replace on from other counties. So right out of the chute, let's thank our steering committee for their good work. Mr. Kennedy, or Alex, I've got a lot of stuff, but I don't want to dominate this. Maybe see how far you want to go. General thoughts, questions for the stuff we've heard from Bree?
Well, this is Keith. I'm just glad we finally got here because I know it's a lot of other counties have been on this for a lot earlier than we have been. And I'd also like to hear a little bit from Bonnie before we sign off. And I guess my suggestion would be, rather than to make any great detailed comments as planning and zoning, because there's still a fair amount of time, it might be more reasonable use of all of our time to make individual comments and have those written up for the public comment period. Because we all have a little bit different priorities, and I don't know that Planning and Zoning Commission is going to come up with an entire set of our comments, and Mara's certainly going to have things that she may want to comment on because she's been in on the process through the whole process. So I think my own opinion is that we just kind of take this all under advisement and don't necessarily file any comments as a commission, but just do it individually. That'd be my thought. And I had actually talked a little bit with the one member of steering committee that isn't here tonight. So partly because I do work with the conservation district some. So, and with that, I'll turn it over to other. I would like to hear from you, Bonnie, if you'd like to.
Let's hear from Commissioner Hanning first, but I agree, Mr. Kennedy, that this isn't a place to wordsmith, and there's simply no provision for us coming up with planning and zoning group comments. That would just, we'd have 2 or 3 meetings, something we'd all have to hash out. So yeah, my understanding of the process is that we are commenting as individuals. We've kind of been given a command performance early relative to that. So yeah, I agree. Let's get everybody to read through this, send your comments in terms of individual issues and wordsmithing and so forth. Sandy, you got something to add to that? Past is a planning and zoning commissioner.
Oh, okay. I still hear somebody maybe talking.
Need to shut their mic off.
Maybe it might be Connor needs to mute. But at any rate, I appreciate what Mike said at the beginning about trying to focus in on sort of the main priorities, because it is a large document, and it's not necessarily handily used by federal agencies, and they probably will just go in and flip through and look for the priority uses and the objectives and priority statements. I guess one thing that I have always struggled with this process is that, as Connor pointed out, you don't have to have a natural resource management plan to be a cooperating agency. That the existence of the comp plan does that for us already. And one of my concerns all along I had hoped that the comp plan would be sort of like the overriding basis for what federal agencies would look at first, and that the statute that creates the natural resource management plans says that it can be used as a basis, not the basis, the only basis, it's a basis. And so I was hoping to see a hierarchy be stated here, or at the county commission level, which early on Connor recommended that it sort of get kicked to the county commissioners to make that policy call. But I just think that if we don't link them together and put the comp plan as the main driving force, that we could end up with conflicting plans, especially if it's thought that this plan doesn't have to go through planning and zoning, that it's really like other counties aren't sending it through their planning and zoning. It could create conflicts down the road between the two documents not matching. And I guess most importantly to me, the comprehensive plan is, as David pointed out in our training, had extremely robust public involvement. And whereas this has been a steering committee doing our best to steer it away from how other counties are writing it, I don't know that we've steered it to the vision that some of the members of our county might have. And I'm hoping the public comment period is going to provide that opportunity. But I most want to see the hierarchy between these two plans be formally stated somehow. Thanks.
Yeah, and we'll get to Bonnie in a minute here, but just I'd like to pick up on that if I could, and it's a question back to Bree and Connor. We have a county comp plan. Conservation District has a natural resources plan. Game and Fish has a whole portfolio of planning documents. There was a Wyoming coordinated resource management program that was completed about a decade ago that produced its own goals and objectives. I assume the Wheaton Hest folks have something similar. Why don't those all serve those purposes that you lined out for us? We got lots of plans out there. Don't they have to be consistent with those and all of the things you listed?
Connor, I'll let you.
So a couple things about that. I'd say the first off, I think that those plans can serve part of that purpose. Where I think that this plan is valuable is a few things. First, it's always good to try to update these plans in the first place, and to always have a new look at a lot of these policies and priorities. And there's been a lot of change, especially in the past 10 years, concerning different federal natural resource issues. And so one of the things that this plan really assists with is we have a lot of, we put a lot of work looking at the legal natural resource issues involved in it. And it's also a plan that has the specific scope and purpose to be involved in these federal decisions, where a comp plan certainly has that's part of the scope of those of a comp plan in a lot of ways, and a comp plan can certainly influence that, but the scope and purpose of a comp plan is much broader than looking specifically at how does the county want to specifically interact with federal agencies. And I think that is why these natural resource management plans can be really valuable, in that way is it's just looking at a different, unique perspective compared to other plans that are out there. It also is, I think, important to note that once again, this is the county, specifically the county's plan. And so while the conservation district, yes, they have a resource management plan, and I've assisted numerous conservation districts in helping draft their plans and helping review the legal policies behind it. One of the things that I would say is the county and the conservation districts might not always be aligned. They might often be aligned, but they're not always aligned exactly together. And so what this plan really does and assists with is that it just ensures that the county itself has this voice. And I think the final thing I would just point out as to why this is kind of valuable and why we're doing this now is there was state financial assistance in getting this plan paid for and created. And so one of the other reasons as to why this is a good time to have it now is while these plans can be pretty expensive to create because they take a lot of time and work to draft these well over 100-page documents, the county is able to get a lot of assistance right now from the state itself to look at these plans. And so that's kind of a lot of the reason why I think this plan was kind of necessary in a lot of ways, is especially the scope, and then the funding aspect just allows for this to be created. And finally, it's just the more often the county can look at these issues and have it as up to date as possible, the better, because things can get outdated very quickly.
It all makes sense, and the availability of funding certainly speaks to all of us who are spending the county's money. But I share Ms. Henning's concern that with all these plans, so I guess I'm hearing part of the answer is, and the language could be clearer on this, the audience for this is the federal agencies, and it's the county presenting to the federal agencies the county's priorities for how they make their decisions. Okay, so I like the idea of a consistency review. Have you guys looked very carefully at all these other plans to make sure that we are not at cross purposes? What I'm concerned about is that taken in isolation, this resource management plan, when you say, oh, the county really believes in X, Y, Z, then some application comes to us as planning and zoning commissioners, and we say, well, we would like to put this condition and this condition on, and somebody brings this back and waves it in our face and says, oh, you told the feds that this is what your highest priorities are, and now you're telling us something different. So I'm really sensitive to us not putting the county in any kind of a position of conflict with any other decisions it has made or might make in the future. So what reassurance can you give us that you have combed those other statements and flagged inconsistencies?
Mr. Chairman, can I address that? This is Mike.
Sure.
I guess
this is Mike Massey. Identify yourself, Mike. We don't see you on the screen. Oh, there you are. Yeah. Okay.
I guess my first reaction is that doesn't seem like that's our job. I mean, the county commissioners asked us to put together a natural resource management plan. And given the background knowledge of the volunteers who have been working with this, we certainly aren't familiar with all these other plans that you're talking about, nor was it a requirement before we got on. So I think you might be asking the wrong people to do that. If the county commissioner, who also understand the plans that you just laid out, felt that this was necessary to put together, it would seem that they see a reason for doing that. And so perhaps it's up to planning and zoning to work with the county commissioners to ask or to address the very good questions that you bring up. And I don't think that we have the background to be able to do that.
I'm not looking for an assignment here. I'm just expressing a concern. And if what I'm hearing is that the answer to my question is no, that the steering committee and consultants haven't and don't intend to do a consistency review with other documents. Is that the answer?
to me, that's not what a consistency review is, but at least in the context of a natural resource management plan. So
I'm using the word
I guess
consistency.
my answer would be that it was never part of our assignment.
So that's a no. I'm using consistency review conceptually, not legally. I think it's important that we review this with consistency with our other documents. And that's sounding to me like the answer is, Bree, do you agree with that?
The answer is no.
No, okay, thank you. Because I think that should be done, and we'll have to make arrangements to make that happen if we have a priority on it.
Can I just, I know that we're not, this is an idea. I mean, if this gets approved, this natural resource management plan, I don't think there's any reason we could not adopt it as part of our comprehensive plan. I know that's came up, and I don't see a problem with that. I mean, we would just adopt a chapter just for our natural resource management plan in our comp plan. I know that's something that you guys are interested in. In our comp plan, our comp plan deals specifically with private land and private land issues. I mean, we do have a public lands chapter, but it's like, well, how do we get people to that public land? How do we get access to the public land? How do we make sure that we're not impacting the public land as, in the private area? So just my review, there's no inconsistencies with our comp plan. And I think if we wanted to go through that process, once this is adopted, there would be no problems going through that process. We would just follow that specific process for comprehensive plan amendments. Just throwing that out there as an option if that's something if that's where you're going, or maybe that's not where you're going with some of the comments. So,
well, I'm picking up on Commissioner Henning's comment that the comp plan was a much meatier document in terms of involvement of the county. There was public surveys done. I think all of us who have had opportunity to read the comp plan are admirers of it. So compared to what it took to develop the comp plan versus what we're going to proceed to finish this plan off in the next 2 months, the idea of, we'll just call this the new comp plan, I'm quite resistant to.
I'm not saying to call it the comp plan, but you can add it to the comp plan.
Well, but then we have the issue that Commissioner Henning raises, is that who carries the day? And maybe the answer to that question is that you planning staff are going to do this, what I'm calling conceptually consistency review. And maybe we need to discuss that, but I do want to make sure that we don't do anything here that we're going to wish we hadn't. And that's a question that has to be answered with a stand back, deep breath. So is that something that planning staff is?
I mean, what are we gonna review? I mean, we can review it to the comp plan, but all those other plans that you've talked about, those aren't our plans. Okay. Those aren't things that we deal with in our duties.
Expose it to review by the comp plan and the decisions we have made in the past. Sure. Going to make going forward. I just am concerned that this thing's very detailed, more detailed than it needs to be. We can get to that, where it says this is what the county thinks ought to happen, and we want to apply a different standard, say, to private lands than we do to federal lands. Federal lands are just a different property owner. Their property rights are the same. Their property managers have been instructed by their owners to consider the county's concerns, their neighbors' concerns, more than any other property owner in the county would otherwise. I'm reluctant to this categorical difference between that set of property owners and this set of property owners. Right, so we can proceed with that.
Mr. Chair,
go ahead.
Can I I want to echo, I think what David is, well, first of all, I did look at the comp plan as I went through. I wasn't aware of these other plans that you're talking about. But I don't think there's any inconsistencies between the comp plan and this plan. And I think David's solution of having the comp plan be amended to incorporate this in would take care of my hierarchy concern. And, you know, I agree the comp plan talks about federal lands and how we want them to be treated, you know, in general ways, wildlife, water and air quality, but certainly doesn't get into the specificity that this document does. But anyway, I think David is proposing a reasonable solution to my hierarchy question. And of course, we can see what the county commissioners think about that. But it would link the two documents and make sure that they're reviewed and treated equally. Thank you.
Thank you. And the other commissioners, the idea is to gather comments from the commission. So dive in at any point.
Well, I also, sorry, I think that I think Keith asked to hear from Bonnie, and I wonder if Bonnie still wants a chance to jump in.
Can you hear me?
Yes, thank you. I'm sorry. Go ahead, Ms. Bonnie.
Well, to me, this plan seems like it brings the county to the table. They're there to be available and work with the federal agencies, which this pertains to. I can see in the future that some changes could be made, you know, looking at the comprehensive plan and all sorts of plans, that it could be updated. But we're not at that point with the comprehensive plan to have it coordinate with this natural resource because of the changes that need to be made. Does that make sense?
So Bonnie wants to give us more work to update the comp plan too, I guess. Which it needs it, right? It's getting a little aged, right?
I don't think we have time. Can you hear me?
Yes, thank you. No,
I think we're a little short on time.
No, that I imagine updating our comprehensive plan and going through the same level of robust public participation would be another year to undertake, definitely considering all on the plate of the county attorneys as it is.
But we could have more public meetings for their input from the public, who would bring forth some ideas on what needs to be, what plans need to go in it. I see this as an evolving thing, not set in stone.
Let me pick up on that point and jump ahead. In the contract under which this plan is being pursued, there's a statement that says Y2's team will begin the NRMP development process by developing a public engagement plan with the Albany County Commissioners and the steering committee. Where do we see that plan? Okay, so that's a question for Bree as the representative of Y2, is that correct?
Yeah. I didn't know if David was going to answer. Sorry. So I think with that, you know, our development with this was, you know, we did the public scoping meetings at the beginning, and then we have, you know, we're meeting here, we're meeting with commissioners, and then we have the public comment period, which is, you know, opening that up with that public meeting. So that's kind of what the public participation plan has been all along for this, in that development. And I guess, David, correct me if I'm wrong.
No, I mean, I don't think there was anything written down other than our timeline of how we're going to go forward. So, I mean, if you're looking for like a separate document that says this is our you know, public participation plan, we don't have that. I mean, we just have a timeline of, you know, these are what's going to happen, so that there's opportunities for the public to provide their comments.
I just read the contract and it called it the public engagement plan and said that there was going to be one. So I just wondered if there was. I guess the answer is there isn't, but it's kind of absorbed in this timeline.
Sure.
Okay. also in that contract, it talks about meetings, and I'm on issue of public participation, meetings in multiple locations, Laramie, Centennial, creation of a website prior to the 30-day scoping period. Is that all going to happen or has happened? Tell me about that. Again, I'm reading the contract, just trying to match it up with what I'm seeing.
Yeah, so the decision was made that we would use the county website to host having the document on, just as people are more familiar with going to the county website for documents and such. So that's been on there. We had put, when we did the original scoping meetings, those were on there. I think as we get closer to public comment, it's the decision of having meetings in multiple locations. We've decided Laramie, if we think it's beneficial to have them in Centennial and other places, absolutely, let's do it. So as we get closer to that public comment period, where we think it's beneficial to have those, we'll set those up. So that's where we've done with those.
Okay,
and that will be under the steer of the county commissioners, as well as the steering committee, as to where it would be beneficial to have those meetings. It won't be done exclusively through us as consultants. That's done by direction of the county commissioners.
So right now, when I read the timeline, I see one public meeting at the end. Is that correct? And now you're suggesting that could be expanded considerably?
Yeah, I think that's a decision to make. We still have a few weeks till it goes out for public comment. That was just a tentative. We know we're going to have one in Laramie because that is, the biggest town or city in the county. So we know we're having one in Laramie. I think after we have this meeting and after we meet with commissioners next week, we'll make that final determination, based on that feedback of where other places needed to be. Have those meetings held.
Okay. The criteria under which we're operating states that public engagement should occur at the minimum in the initial draft and final plan development stages. So walk me through how you're meeting those requirements.
So for the initial stages, we held those public scoping meetings, and the comment for folks to submit comments to the plan has been open the entire time. I would say now we're in the draft. We have a draft, and I want to make sure this is a draft. This is not a final plan. This is a draft. So we're in that, and that draft phase of getting that feedback on what the draft has. And then, as it goes, once that public comment period is over, and it goes to the county commissioners, that's a public process as well. And there's opportunity for comment and stuff in that final phase. So I'd say the initial phase was the scoping meetings, gathering that input from the community in those initial scoping meetings. We've put that together, and now we're in that draft phase where we have a draft, getting public comment on that draft, incorporating that, and then getting that to county commissioners, where there's still the opportunity for public comment there as well.
Public scoping meetings? I was puzzled by the plural.
It was held in Laramie in August, and then we had a virtual component as well.
So we had one meeting, which was the one in August, and then you invited comments on the county website. Is that correct?
Correct. Yes.
A little feedback on that. I attempted to write to the provided email twice. It got no response. Called your office once. It got no response. So you might check if your pipeline's open in terms of receiving comments. Did you get a lot of comments?
We got a few, not a ton. I think it's easier for people to comment on something that they can comment on rather than just we didn't have anything on paper at that time, but we did get some good feedback, and we did get good feedback from the few folks that attended the public meeting in Laramie. So, and I will double check that email.
Okay, thank you.
Yeah.
Another part of the guidance addresses the federal agencies. Quote, counties are encouraged to involve federal agencies that manage public lands within their counties in the development of the county natural resource plans. as I said a minute ago, my feeling is that the federal agencies are the property managers for the property owners, and that encouragement should be required. So my question to you is, what provisions have been made for meaningful involvement by the property owners in the development of this plan? Is that all in the future, or you got a plan for that? How's that going to work?
So from my understanding, this draft document has been shared with BLM and Forest Service. They were not part of the steering committee. I'll say that up front. We are developing this for the county. This is the county's objectives and the county's priorities for federal land management. Sometimes it's hard to have those federal land managers in the room when you're, having those discussions, but they will fully be participating. The plans have been provided, and we will make sure they know when the public comment period is open. And if they would like to have discussions on that, we're absolutely open to that. But that public participation and providing that draft to them now is the involvement there.
Has the draft been provided to them by your group?
I thought that, David, didn't it go out to BLM and Forest Service?
Yeah, I sent it to BLM. I think Mr. Hinckley sent it to.
Well, I sent it to a gentleman I know in the Forest Service. I haven't had any contact with BLM. Again, when I read the requirement that they be included in the development, I assumed that might mean something slightly larger than allowing them to make comments like they were simply a citizen of Albany County. But I guess what I'm understanding you to say is that your notion of involvement of the federal agencies in the development of the plan is that they will be provided the same opportunity to comment as anybody else in the public. Is that correct?
No.
Bern, are you reading from the contract to I-2, or are you reading from the directions from the governor's office?
When I looked for direction on this thing, there were three documents I looked at. One was the state statute, one was the governor's criteria, and the third was the contract that was signed with Y2. So what I'm reading from there, I believe, is in the governor's criteria.
Yeah, and so there's still plenty of time to do that. As you and I talked about, maybe the best time to do that would be as this document goes out to the public, to ask the Forest Service and the BLM to come in and talk to the county commissioners, because that's where we really want the rubber to meet the road anyway, is to have those folks talking with each other. So it might be more appropriate, and it's certainly still in the development age, or at the development stage, to do it at that point.
I guess my point is just I would like to see an explicit involvement of the property owners. If this was any other property owner in the county for whom we were making plans and establishing priorities, we don't have to do what they tell us to, but it would be obvious that that person would be heavily involved in the development of the plan.
Yeah, but the steering committee wasn't told to go do that.
I'm not concerned about who has to do what. Mr. Kennedy, did you have a comment?
I did on this, and then I want to go back to something just a bit earlier. One, this is the county's plan. This is not BLM and the Forest Service's plan. And so I think it's appropriate that they be brought in after the steering committee has gone through. And so it's entirely appropriate to do this the way that it has been done. The other comment that going back to Bree, I think it'd be very worthwhile, given the time of year when this will happen, to have a public comment session up in Rock River too, just because the time of year, and there's a lot of folks up there that are on BLM and Forest Service permits, and they need to be able to have input without as much travel and time as it's going to take if they would come to Centennial or Laramie for those meetings. And part of that's just time of year. So those are my comments, Mr. Chairman.
No, thank you. And I think that's consistent. What I've commented on so far is my concern that this be a product that can legitimately be represented as Albany County. That's the public participation part. I was pleased to see that there was supposed to be a public engagement plan. I think that's important. And I think it's also important to extract from the governor's criteria that the landowner, in this case, people of the United States as represented by their management agency be explicitly involved. So I would encourage you to do so as you go forward. And if that means sitting down with representatives of BLM Forest Service, then you should do that. And again, to speak to Mr. Massey's point, I'm not sure who you is in this case, because I'm looking at Bree's picture as the paid consultant. I recognize that the volunteers of the steering committee have done a tremendous amount of work, like the volunteers on this commission. We're not looking for an additional assignment, but I'd like to see a faithful attempt made to satisfy the governor's criteria and the contract. All right, I'm prepared to move on to some more general comments about the scope, unless others want to dive in. I thought the introduction as written was not as embracing of a cooperative relationship as it could have been. Maybe that is because it was adopted from other plans. So I'll offer you in writing some comments along the lines that Mr. Massey articulated. What we're trying to establish here is a cooperative and respectful relationship between county, Albany County, and the property owners, and that I think could be more carefully articulated. Second thing, the legal framework struck me as argumentative and unnecessary. I'd like to see all of that legal analysis moved into an appendix, if not eliminated entirely. You don't need to argue to the federal government what their obligations are under FLIPMA and NEPA and so forth. So as just an editorial suggestion, organization, the document, this reader read all that as extraneous and made it difficult to plow through. And it really wasn't a policy statement on the part of Albany County. It was a legal analysis provided by the Bud Phelan Law Office. And I'm happy to have it marked as such and included as an appendix. It would certainly make the document easier to read. But with respect to the scope, too much in some places, too little in others. There's a huge amount of material here. And the statute, the criteria and the objectives create lots and lots of bits and pieces that you'll get a lot of comments on. But I'd like to pick up on Connor's statement earlier in this conversation. These are things that they should identify what the county is particularly interested in. Everything can't be top priority. When I read through here and I see what strike me as much unnecessary specificity, I don't think the county, for example, needs to have a policy on aerial gunning of predators. I don't think the county needs to have a policy on irrigation efficiency, on the management of landslides. Those just caught my eye as everything. Those are all of those are our priorities. What do we have? 100 top priorities. We need to trim that down and give it a little bit more focus. As an example of too little, I'll totally echo what Commissioner Platt said, the recreation piece. I think for all the hard work you guys have made, and partially it was because you were coming from templates from other counties, that's where I think this particular draft seriously misses the boat. If you were to ask the people of Albany County what's important about the federal lands to you, I'll bet the answer 99 times out of 100 would be recreation and open space. What part of management of federal lands has played in anyone's decision to move to Albany County in the last 50 years would be a way to ask ourselves that question. What aspect of federal lands management has anyone growing up in Albany County looked at, made them want to have them decide to stay here? And I'm guessing the answers would almost all go to hunting and fishing and hiking, biking and rock climbing and snowmobiles, four-wheeling and driving across the snowies to look at the wildflowers, picnics at Lake Marie, skiing at Happy Jack, keggers at Hidden Valley for the high school kids, going shooting out on North 9th trails. That's what the federal lands mean to the people of Albany County in my book. And that's what we want the county to step up to the plate on and represent as our interests in federal land management decisions. So I was disappointed not to see objectives and priorities related to trail maintenance, seasonal closures, restrooms, parking, signage, shooting restrictions, forest fires, all the things that contribute to federal land management, that contribute to the quality of life in Albany County. I've looked to Pilot Hill. It's probably as widely popular project has been as conducted in Albany County. And it only includes a very small bit of public lands, but it speaks volumes about the importance of open space, recreation, and environmental quality to this county. I'd like to see where in the inventory of natural resources do you guys address that critical resource? I've been doing the counts for the Medicine Nordic Association. We get 30,000 skier days a year through the Happy Jack Trailhead. I'll bet the snowmobiling on the snowy range. Well, I've seen the snowy range snowmobiling shown up as the second most popular spot in the entire nation for snowmobiling. I would like to see the inventory of natural resources reflect that. Beatavoo is a world-class climbing facility. That ought to be part of our attention, our priorities, if you will, for management of federal lands. And as we all know who live here, the climbers at Beatavoo have a lot of really interesting and hot button issues with respect to federal lands management. I'd like to see, and whether it's the consultant steering group, I'm agnostic on to anticipate an objection from Mr. Massey. Talk to the folks at MBNA, BikeNet, Motor Sports Groups, Kyle Unlimited, Rocky Mountain Elk Foundation, Snowmobile Association. There's huge interest in recreation and the amenities that are provided by federal land management. I think those need way more emphasis here. University has recently opened up a whole new program in outdoor recreation management. They've got a series of excellent publications on open space. Those should all be part of this plan if it's legitimately going to represent itself as the county's statement on the management of federal lands. All right, there's my speech on what's missing from this plan, and I'd like you guys to rise to that as I think is the top priority. All right. Response to that, comments, can you do that? What do you need to help with that project?
No, I think those are valid comments, Chairman, and we can get those incorporated. I think if we could get your notes on that, that would be helpful there. And agreed, we can beat that section up more. Probably we'll wait until public comment, but we can probably get that incorporated as well. We'll see what that timeline looks like, but very much appreciate your comments there. I will make one comment on the templates. Yes, the template looks like other counties, and actually this one looks a lot different. That is because with the state funding, there was a template that they asked counties to use and made sure that and that was put together by the Wyoming County Commissioners Association. So that is why county plans do look similar across the state, as there was a template that was provided to ensure that those resources were addressed in each county, as they're trying to have, counties also have, not similar plans, but plans that, the Rollins BLM office encompasses both Albany County and Carbon County. So to have a little bit of, consistency in those documents. So that's just the comment on the template. Although Albany's is very unique, and I appreciate that from the steering committee.
Oh, and thank you for that response. And I did recognize as I was going through it and asking myself, why are we talking about some of these things, that those are coming from the criteria. We've got 4 pages and 9 priority statements on noxious weeds. That seemed out of proportion with the 3 short paragraphs and a couple of thoughts about recreation to me. Now, again, we don't have to count words, but let's try to get some proportion in here that reflects, as Connor said at the very beginning, absolutely right. What are the most important things for the people of Albany County, and where does federal land use management fit into the quality of life that the county is deputized to look after? In that spirit, are there other comments just of a general nature from the commission? Are there things that you would like to see more of or less of in this plan? And maybe you haven't had a chance to look at it hard enough to say. We had a little comment from you, Commissioner Platt, Commissioner Hanning, Commissioner Kennedy. Any thoughts on that level of just scope, coverage? I guess that's a no.
It's a laugh.
That would be a no, yeah.
Okay. So the hour is late. Where we go from here, it makes perfectly good sense that we need to provide our comments in writing so that Bree and Connor have something to deal with. The involvement of the steering committee, I'll leave up to you, Mr. Gertz. We have levied on them very substantially to this point. But I'm certainly not in a position that I would pick this up and say, make it county policy. Let me offer one additional small example. New or expanded dams and reservoirs should be pursued. I do not believe it is fair to represent the people of Albany County being in support of just blanket, let's dam up streams. I suspect if you put that out to a public vote, you get quite the opposite reaction. So each and every one of these objectives and priorities needs to be carefully looked at by anyone who's commenting on this plan to ask themselves, is that actually congruent with what you think rural use management priorities should be? So I've said too much. I'm sure I'll agree with that. I'll shut up.
Mr. Chairman,
Yes,
Mr.
sir.
Chairman, I'll throw in one other thing. And I think we also need to remember our hierarchy in relation to the leverage that perhaps the governor's office might have when issues come up. So I think there's also a point where we need to align with what the reality is of what perhaps Water Development Commission may wish to do with the concurrence of the legislature and the governor and those kind of things. And I think if we wish to see planned growth, we need to leave all of those options open. And so I think that's one of the reasons that some of these documents seem somewhat open-ended, because we don't know what's down the road 15, 20 years from now. And that's not to say that this document won't be reviewed, but we need to leave some options open here when we go through these. And this is essentially, for lack of a better way to put it, a discussion document when we interact with the Forest Service and the BLM. So we also don't want to close out options because of what we've put in our natural resource management plan. And with that, I'll shut up and let us all get on with our evening.
Okay, no, and I agree with that, and that's exactly the test should be subjected to. And so circling clear back to where I started, here's some proposal comes along to put a new dam on Nash Fork, and the county comes forward and says, we think that's a terrible idea. Well, then the feds who want to promote it say, well, it says right here in your resource management plan that you want to do that. So I absolutely agree. We want to leave our options open. But first and foremost, we want this document to faithfully represent the priorities, as Connor put it right from the start, for people of Albany County with respect to federal land use management. So if we're agreed on that point, we can move from there, Mr. Gertz.
Yeah, so yeah, I appreciate this opportunity that we've had to come and discuss this with Planning and Zoning Commission. I just want to emphasize the time and effort that the steering committee has put into this, as well as our consultants. I am very appreciative. I am not an expert in any of these areas. This group was put together with a bunch of people from some diverse backgrounds that have really added to this document. I mean, obviously this is a draft document. I hope that we understand that it's a draft document. And I think we've gathered some great information, but I don't want my steering committee here to feel like you guys have put an amazing amount of work. What was brought to us by the consultants was good, But what the steering committee did was make it Albany County's document. I think there's probably still some issues that we need to work through. And to know if this is a document that the public truly likes and understands, that's why we're going to go through a public process. We're going to have those discussions with people of Albany County to see if there are things that we need to change, if there are things we need to look at. I want planning and zoning to know that these folks worked hard. They spent a lot of time. They're all volunteers. I mean, I do this for a job, I'm here, I have to look through these things and I'm trying to keep up with everything else, but these folks have taken hours and hours and hours of time to look through these things. So I just hope that they know that I appreciate our consultants. I appreciate Bree and Connor and all the work they put into this. It is a big document and there was a lot of work. So that's all I have to say. Sorry.
Totally agree. We're not quite done. All right. If there's nothing further to say on that topic, I'm looking at the screens. Mr. Platt?
I wanted to make one comment. I apologize. It's just one minor comment is there's been a concern that this would handcuff the county if the natural resource management plan says one thing and the county might want to do something else. And I want to emphasize, and I'll leave it at this, is this document is not a binding document that will force the county to do something they don't want to do. This document is purely an advisory document that supports consistency review. And if the county decides, 2-3 years down the road that they don't like a policy in this, they can change that policy. They can also tell the federal agencies that policy has changed, and they're not married to having to stick by anything in this document. And that's something I think is just really important to note is the county is never going to be handcuffed by this document. This document is supposed to try to enhance participation, not deter it.
Fair enough. Thank you. Okay, let's move on to our remaining agenda, which we should be able to dispatch fairly quickly. There was an area for commissioner comments. I'm guessing that we're not going to avail ourselves of that. Looking around. All right, fair enough. Everyone's going twice. We need to do one thing and appoint a member to the USAC. Mr. Gertz, would you like to explain that to us?
So this is a very big time commitment. If you want to be on this committee, they meet once a year for about an hour or two. So, that's all you have to do. So basically the USAC committee is the Urban Systems Advisory Committee or Commission. I think it's committee. They're kind of guardians of some money that comes in for federal money that comes in to be used for a system of streets and things that we have on a couple of maps. There's 2 different maps that they oversee. One is the major street plan. That map is like a 10-20 year plan. It looks at major streets in Laramie and outside of Laramie. These streets that are important are the collectors and the arterials. I think they break up into minor arterials and major arterials. And then there's a functional classification map. So we've got our planning map, and the functional classification map is actually determines how they are functioning. Are they functioning as a collector? Are they functioning as a local? Are they functioning as an arterial? And if you get on this committee, you'll know what all those terms mean. This is it's really a good opportunity. You get together, the folks that are in it, there's a group from the city, and then there's a group from the county. And then we also have some representatives from the university and from YDOT that make decisions. So this group they get so much money, like I think it's $500,000 a year or something like that, that comes to them for the federal government. And they have a prioritized list of different roads that are on those maps that they want to do a project. The current number one project is the Bill Nye project. They want to get Bill Nye built from the high school all the way across. And so they're collecting money to do that. So in a nutshell, that's kind of what they do. They oversee the two maps. They prioritize projects, and then eventually they'll complete a project. So if there's anybody on this board, I mean, it's up to you guys to nominate whatever. But if you guys would just appoint somebody for it. They do have a meeting in March. Is that a 2-year appointment? Yeah, it's a 2-year appointment. There's a meeting in March, and I can get if whoever's interested in that.
So there's a designated position from planning and zoning?
Yes. Okay. And it doesn't actually have to be someone from the committee. You can appoint someone else, but it would be nice if you just appointed one of you because you guys know each other right now.
Well, who's doing it right now?
Nobody.
Nobody.
So, so I think is what happened is they changed the bylaws a little bit. And so now there's an appointment from this committee. I think there actually was one before, but the board always appointed it, but that's not how it's supposed to be done. So I don't know.
So we obviously choices Mr. Fine because he's not here, right?
No, Mr. Chairman, I would actually like to be on that because I don't know that any of the rest of you have actually seen one of their street plans that they've done in the past. Because we have reviewed those in the past. David, correct? Yeah. So
when they do those plans, they actually have to come through this board before the board of county commissioners get approved. So
yeah,
Mr. Chair,
so
this makes it sort of easy, doesn't it?
Is there any objections to Mr. Kennedy being taken up on his generous offer?
well, I have my own priorities. I would like to travel down 9th Street without a tank.
If a paved road shows up at your doorpost as a result of this, we'll. Do we need a motion on that, Mr.?
That'd be great if someone would.
It sounded like a motion in making, Mr. Platt.
Yeah, well, I'd move that we have Keith serve this position here.
Is there a second for that?
Danny will second.
Motion has been moved and seconded to appoint Mr. Kennedy to the USAC as the representative of the Albany County Planning and Zoning Commission. Is there any discussion of that? Hearing none, Mr. Kennedy, what do you say?
Aye.
Henning?
Aye.
Aye. Hinckley? Aye. Done. Thank you very much. Next item is our next meeting. The only suggestion I've had there is if we're all amenable to it, we go to a open to the public in person attendance. That would be the next step away from total Zoom like last year. Are there any thoughts, concerns, preferences on that?
Mr. Chairman, I already have made travel plans and I hope to be back, but I am not absolutely certain that I will get back I'm supposed to leave Great Falls that morning, so no promises that time of year.
And I guess my suggestion would not be to abandon Zoom, but rather to make it an option that we would open the meeting to the public in-person attendance. And also, I would like to continue to offer Zoom.
similar to the board of county.
Yeah, similar to the Board of County Commissioners. Keep the Zoom option open forever. I think that's just a ticket for folks out in the northern parts of the county, the kinds of issues we had with Commissioner Spiegelberg's attendance last year. So that would be my preference, if that's acceptable to the commission.
That sounds great to me.
Sounds fine to me.
Ms. Henning?
I'm going to put on my calendar that Keith is going to bring a winter storm on April 13th.
It might be like the one last March and nobody may go anywhere.
Right. I think the hybrid approach of Zoom and in person sounds great.
Okay, let's consider that done and advertise accordingly. Mr. Hirsch? Sure. Citizen public comments. I think we whittled them all down. They'll have to hold their fire until next time. Anybody out there? Okay. And we don't need a formal motion to adjourn. If there are no objections, I can declare it so as chair. Hearing none, we are adjourned. Thank you very much for your patience.
Thanks. Good night.